Hi guys, it's Kathy. I hope you're doing well. So we went through the whole Michael McDonald fiasco a bit ago, a couple months ago, and we did all the videos, and it was crazy. There's more. Donna sent me a message the other day. She's like, "Hey, there's 2 more videos up," and then yesterday she's like, "Hey, there's 3 more videos up." Well, I think we got 4 more videos. So there's from May 5th, 20. Oh, well, there is more. There's more than that. But they're still tiny. Oh my gosh, there's more. 11 days ago. Oh, that's John Scott. We did not do John Scott, so I'm not going to do John Scott. It looks like right here, 4 days ago, they put up a 15-minute video from March 2023. And then from April 4th, 2023, it's another small video. And then 3 days ago, 1 day ago, we might be able to get, no, we won't be able to get it through all these today because this last one is bigger. So we will start here. And we'll probably get all of them done today except for the one. Tona, thank you so much for finding those. So good. This is going to be so good. So yeah, I'm looking at our Nevada judges. So if you haven't seen that site yet, go and look at what they do. They are professional and they are so good. And the link is in the description. Let's start with this one. And let's have sound.
Related to Mr. McDonald and what he's required to do to modify custody.
Judge, can I speak?
Okay, Mr. McDonald, I'm going to hear from you in the courtroom. Can unmute.
For the record, Your Honor.
All right, this is case D. A petition for termination. Counsel, your appearance and your bar number.
Good morning, Your Honor. Jack Fleeman, bar number 10584 on behalf of who's also present via Blue Jeans.
Okay.
And I believe this is a closed matter, Your Honor.
Yes, we have court observers. They are court clerks in training. Do you still have an objection?
Not to the court clerks, no, Your Honor. And my client, I believe, is sitting with her spouse. He probably would need to move off camera.
Any objection, Mr. McDonald? The persons in the courtroom are court clerks in training. Do you have any objection to them sitting in on the hearing?
No, I don't, Judge.
Okay, I'd like to swear in both parties before we begin, so I'll have the court clerk swear them in.
Ma'am, please stand and raise your right hand. Sir, please raise your right hand. You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Ma'am, can you please speak louder? We didn't hear you.
I'm sorry, I do.
Thank you.
Okay, Mr. Fleeman, you filed this petition for a termination. You set it on the uncontested calendar, but Mr. McDonald has filed a few pleadings. Were you served with those pleadings?
I was served with the reply, and I believe he refiled it, so I think it's the same pleading.
There are 2 replies. You are correct. As far as the case, in the reply, Mr. McDonald has stated that the children are living in the state of Oregon, and that there is a case that's been opened in the family courts in Oregon. And so I don't know if this brings up a UCCJEA issue, because I still have a dad that lives in Nevada. Mom and the children moved to the state of Oregon. Dad admits that the children have lived in Oregon for more than 6 months, and that he believes that the children are residents of the state of Oregon and that he wants to proceed there. But this is a question that the court must answer.
Right. In our position on that, Your Honor, is that Nevada retains exclusive continuing jurisdiction because Dad does still live in Nevada. Moreover, we don't have any. I was going to need to mute.
I think if the courtroom can mute, it'll get rid of the echo.
So we don't have any evidence that Mr. McDonald has filed anything in the state of Oregon. We've looked online. Oregon has kind of a central filing system, and we don't see anything. Moreover, Mr. McDonald didn't include anything in his filing with related to where he filed, the name of the court, the case number, anything. So we don't have any reason to believe that anything has actually been filed there. So at present, there would be no ability to do a UCCJEA because there's no active case that we're aware of. Even if there were, Your Honor, we would submit that the court should retain continuing exclusive jurisdiction because of the long history of these parties in this case. This court has issued specific orders related to Mr. McDonald and what he's required to do to modify custody. And our position is that we think he would try to move it to Oregon for the purposes of convincing that court that something different should be done rather than what this court has already ordered.
Judge, can I speak?
Okay, Mr. McDonald, I'm going to hear from you and the courtroom can unmute. There is also another issue whether you are seeking court-appointed representation. The question will be, can you afford an attorney? Do you want an attorney present to speak for you to answer these legal issues?
So Judge, am I on? Yeah. So Judge, my first issue I'd like to bring up a conflict is that my Pecos Law Group was actually conflicted out as my dad retained them previously in the past in front of Judge Marquis. And there was a conflict of interest there. My ex was also a paralegal and a legal assistant to Mr. Shapiro, who owns Pecos Law Group. So there was a conflict there. I don't know how she's able to go and have them represent her here. So that's one thing. And no, Judge, if there, as right now, I would like an attorney appointed if there's one available. As I just got off parole last month, which I've been waiting to get off parole, which in your orders, you said to wait till the incarceration was completed, which it just happened at the beginning of February of last month. So I was waiting to file anything in Oregon, which I have been filed in Yamhill County to go ahead and seek visitation of the children.
Okay, so you haven't filed anything yet. So this is a new
I have
issue I wasn't aware of about the conflict of interest, but I'll have to have Mr. Freeman respond to that. But is there anything else you wanted to say, sir?
Yes, Judge. Like I said, I would like either the jurisdiction to be challenged as I'd like it to be transferred to Oregon and get clear orders. As we discussed last time, to get a mental eval, it wasn't just from Dr. Holland or Quist. You put on record that it was any psychologist, which I did get a evaluation done by Dr. Clausimo out here, and then I got incarcerated right afterwards while I was on bail, that $100,000 bill.
Okay, before we get to the merits of the case, we have these three issues: conflict of interest, court-appointed attorney, and UCCJEA jurisdiction. With the request for the court-appointed counsel, before we discuss the merits of the case, are you able to afford a court-appointed counsel? Are you working right now?
I just started working, Judge, but like I said, my funds have been completely depleted. I still owe my grandma a bunch of bail money and my mother for helping me through the last 3 years of being incarcerated because of trying to seek custody of my children, which have been completely frustrated by the court system and my ex-wife. So, yeah, Judge, right now I am seeking appointed counsel.
Yeah, do you have outstanding legal fees from your prior cases to pay also?
I do have other fees I have to pay related to the case, yes.
Okay, let me hear from Mr. Freeman on the appointment of counsel.
Right, regarding the appointment of counsel, my understanding is that he would need to prove indigency, and we don't have any financial information regarding that, Your Honor. So I don't believe that he's entitled to appointed counsel unless he's indigent, and there's no evidence of that. He is working. He hasn't filed any sort of financials, so we don't have enough information on that issue.
Anything in response, Mr. McDonald?
Well, first of all, can we address the conflict issue? Is he allowed to represent my ex with that being conflict and having that confidential information from my mom's divorce? And in my case, is that an issue that we can bring up in the court right now?
I intend to get to that, but right now, the question is, should the court appoint you a court-appointed counsel? And that way, if we do give you a court-appointed counsel, then your lawyer can speak to you as to, they could speak on your behalf to address these other underlying issues.
Judge,
So,
I've been doing, like I said, I've been working, and then I lost my job because of these charges. I was, like I said, going between different jobs, and I'm still indigent in the court's eyes. So that's why I'd like to seek counsel. And this is a complex legal matter, and I would like to have the jurisdiction go to Oregon, as my children have been residing there for over 6 months. There's no allegations of abuse or anything like that, and that they should have that jurisdiction to be able to see the custody visitation matter. As now I'm
all right.
out of custody.
Well, this will be a short hearing. So what I'm going to do is temporarily for now, give him a court-appointed counsel, at least until the next court hearing. I will have Mr. McDonald file, because he's able to file, he's pretty adept at it, proof that he is indigent, how much debts he owes, legal fees he owes, and that he cannot afford court-appointed counsel. Because this is a termination of parental rights case, it's the remedies are pretty severe. So I'll err on the side of caution and give him a court-appointed counsel. Well, when we come back in the next court date, court-appointed counsel will appear on your behalf to confirm as counsel. With the conflict of interest, I want you to put that in writing, Mr. McDonald, or have your court-appointed counsel help you file a conflict of interest issue. You may just file a supplement, okay, or just file a brief on that. And also, please consult with your court-appointed counsel as far as the UCCJEA jurisdiction. Your counsel can help you draft something regarding that. And since we're going to come back in another court date, you do intend to file an Oregon case, an Oregon case number. So by the time we have our next court hearing, I would like to know if you do file. If you don't file, then this court is keeping the jurisdiction.
Judge,
If you don't file and show me a case number.
I did file, Judge, and they got kicked back because they need a certified order. So I submitted the last order for foreign judgment, and they kicked it back. I requested a record, and they said it would take up to 14 days. I was downstairs trying to get the thing today, so I shouldn't have that case number for the next court.
Yeah, so if you're in the court building, you can get either a certified or exemplified copy.
And could
so
I
that
clarify,
you can.
and Judge, could I clarify the last
Mm.
order that you put for the brief? Was it the brief focused assessment and the order put on 4/15?
Well, I can't discuss that today. Today is just basically to appoint you a lawyer until the next court hearing, and have your lawyer file the necessary paperwork so that we can address all of these issues. And it also gives you time to file the Oregon case.
I don't understand what's going on. Someone tell me. If she's appointing a lawyer, this is criminal, not civil. So what did he do now?
And as far as the interpretation of the order, please consult with your court-appointed counsel. It will be a family law attorney that will be appointed for you.
Wait.
Okay.
She's appointing a family law attorney? A court-appointed family law attorney? That doesn't make sense. I don't understand.
Before you leave the courtroom, can you leave your contact info or confirm that with the court clerk, your email address and telephone number so that we can pass it along to the selected court-appointed counsel? The court will appoint one for you.
Yes, Judge.
Your Honor, how
Okay.
far out would you like the next hearing?
Anybody, normally for confirmation of counsel, I usually put it a week out, but Mr. McDonald wants to file an Oregon case. So, you think you can get it filed, well, about 2 weeks, Mr. McDonald? I don't think anybody's in a rush here.
Yeah, 2 or 3 weeks would be good, Judge. 3 weeks. More.
Mr. Fleeman, your availability? I mean, if we can, what'd you say?
First week of April.
First week of April?
Your Honor, we'll set this on Thursday, April 6th at 9 a.m.
Okay, we'll take you first thing in the morning. On April.
I have another hearing in front of.
Mr. Fleeman, we're not able to hear you.
You can't hear me?
Can you try again?
Can you hear me now?
Yeah.
Okay, so I have another hearing at 9 a.m.
Your audio kind of fades in, fades out, just
Yeah,
where I
right.
do the headphones.
Okay, Judge, we
It's
can.
working.
What about the 4th at 9 a.m.? Tuesday the 4th.
That works. That works for me.
Okay, Your Honor, we'll set this to come back on Tuesday, April 4th at 9 a.m.
Okay, the order will be that the court will appoint a counsel for Mr. McDonald. Mr. McDonald is to file,
The motive of this, not the motive. It's early. I can't think of the word. Anyway, what we should learn from this right now is never trust anybody named Michael. Oh, hi, Michael. Hey, Michael. Fozzie, don't worry. They'll be back under a different name. It's all good. He's still here.
some type of a brief regarding his indigency, and also his counsel will advise him accordingly on the UCCJEA. Mr. McDonald is also to file a brief on conflict of interest, and he should file it as soon as possible, but he has to wait till he gets his attorney, Mr. Fleeman. And I know you'll have to scramble to file an opposition or a response, and then we'll hear everything on the 4th.
Sure, Your Honor.
Okay, thank you, everyone. Have a good day.
Thank you, Your Honor.
Thank you.
For a long time in this jurisdiction.
It's sealed, so I can't even I can see the documents. I can't pull it without calling the poor court clerk or JEA and begging them to get clarification for the new judge so they don't get hit in the face with all this stuff.
Muted. Okay, McDonald. Thank you for your wait. This is case D23. It's a sealed matter. We're here on the TPR case. We've got a confirmation of counsel, Valerie Fuji. Let's start with the petitioner's attorney's appearance first.
Good morning, Your Honor. Jack Fleeman, bar number 10584, on behalf of my client, who is also present via Blue Jeans.
Okay, you could lower the volume on this in the courtroom. Okay, for the respondent, Michael McDonald.
Val Fuji, bar number 5955. I'll be confirming as counsel on behalf of Michael McDonald. There he is. He is now present on Blue Jean as well.
Thank you. And you have Missy, your legal assistant?
I do, Missy, my legal assistant.
Okay.
I'm getting old, Judge. What can I say?
All right. So I'm in and out here like a flash because the permanent judge in Department C will be selected by the governor this week. I anticipate in about 2 weeks.
No. I'll tell you why I'm not. No. Because I don't know if she's going to annoy me yet. I have a feeling she's about to annoy me.
I'm praying 2 weeks. I've been here for a long time. You will have your permanent judge. So what we do we'll set up a trial.
Yeah, we could set it for trial, but Judge, I don't know if you recall, we at your last minute order, court's indulgence. Your last minute order, you asked us to, let me find it, yeah. Your minutes from March 7th asked for the court to file proof of him being indigent, some pleadings regarding conflict of interest, which I think will be moot now based upon the court's representation, and also regarding the Oregon case filed. And my apologies to the court, although I was appointed last month, Mr. McDonald and I did not connect. We had the wrong email and phone number until this week. So I spoke to him for the very first time yesterday, and I was inundated with information. So what I was going to ask the court to do at this point, because there is, in response to the court's orders, there is a application for court-appointed counsel that the clients or parents are required to fill out in CPS and DFS cases to prove they're indigent, similar to the same form they fill out for the public defender's office. I want to give that to my client today, get him to sign that, file that. In addition, the court was concerned about some UCCJA issues, and I kind of agreed. So I looked at it this morning, Judge. I understand Mr. Fleeman will have some arguments because an answer was filed, but there's an argument of under the factors under 125A, 0.325. That's the forum nonconvenience. So we're going to have to do an analysis of those factors. So I'll do a brief to that. He also had an issue regarding the change of venue. I think that's in RS 13.050. So I said to him yesterday, because we spoke for the first time, let me research this. Let me get access. I'm going to ask to continue this 1 month and then set a trial at that date so we can really find out. He did, in fact, file, Your Honor, and I'll let Mr. Fleeman know. Call me after court if you have time, Mr. Fleeman. We will connect sometime today or tomorrow. He did file. He filed to adjudicate a judgment. I have the case number in Oregon. Keep in mind, though, Judge, he filed that regarding, and Mr. Fleeman, the custody case, not the TPR case, which is a completely different case number. So there's some apples and oranges there. I wanted to get clarification for the new judge so they don't get hit in the face with all this stuff. My last request, Judge, before this matter either gets continued or a trial is set, is that I get full access to the divorce case, which is D15. It's sealed, so I can't even I can see the documents. I can't pull it without calling the poor court clerk or JEA and begging them. So if we could put that in the minutes, that I can have access to that, because that's really pertinent, then I'll be better prepared to argue what the court ordered at the last hearing.
Mr. Fleeman.
Yes, Your Honor.
Oh, wait.
Yeah.
What venue? Change of venue to what county?
So, Judge, I have a document. It is State of Oregon, County of Yamhill.
Oh, not.
And this is where Candace resides.
Yeah, that's jurisdiction, not
Yeah, that's
venue.
forum. That's not venue.
That's true. That's another issue that
Yeah,
he brought up yesterday, and I went, oh gosh, let me get the information from you first. Let me flush it out.
That's another
And,
issue we're going to sue
unfortunately, our
for.
first time speaking was yesterday, so I'll get up
Yeah.
to speed.
Okay, there's
Yes.
a lot on the table here, but let me hear from Mr. Fleeman.
Sure, Your Honor. I mean, there's not much we can do if Ms. Fuji was only finally able to reach Mr. McDonald yesterday. I had some brief contacts with Ms. Fuji within the days following the last hearing. She had advised me that she had tried to reach out, couldn't contact her client. I did tell her at that point, though, that he was alleging a conflict. He needed to brief that issue. He was saying he was indigent. The court wanted information on that, and that we needed the Oregon information. My understanding is that the Oregon case was just filed within the last couple of days. Despite having a month to do it, it wasn't done. Our concern is that given the history of the divorce case and things that have happened, there's always delays, and it costs my client time and money. And so I'm happy to hear the court is willing, sounded like, to set a trial date, get this case going, because if it stalls out in Oregon, we're just going to be sitting here. At some point, there may need to be a UCCJEA. I don't know that we need to brief that now. I don't have enough information on the Oregon case we would like to at least have copies of what's been filed. So I understand, and I told my client that there's going to be a new judge sitting in this department soon. There's a possibility, I don't know. I know this case is long and lengthy, has a long history, at least the divorce case. Judge could be, not able to take the case potentially, depending on who gets appointed. I don't know what the case may be, so that may extend it even farther. So I'm fine with having another hearing set out, Your Honor, having a trial date set, and we can just go from there.
Exactly. Okay. So what month as a backup?
I was just going to ask for,
Yeah,
I was
we
just
don't-
going to ask 30 days for a continuation of the status and then
Yeah.
a regular scheduling order for a trial, because this is a case where I would probably request an expert for reunification therapy. And so
Let me
I need a
give you-
regular scheduling order.
Okay, so let me give you a preview. Clearly, TPR cases fall within the, do they fall within the UCCJEA?
Yes, Your Honor.
Yeah, so Nevada has always had initial custody jurisdiction and continuing exclusive jurisdiction. This is gonna be a forum convenience factor analysis, so I think the attorneys, could probably just get their briefs in whenever you can get your briefs in. I don't think I'll put a deadline, but it's coming down the road. You want to get it all briefed in. And the Oregon case, there is a case number filed now. I could certainly contact the Oregon judge and schedule it immediately, sometimes as fast as a week, sometimes a couple weeks. I'm here for the next, probably this week and 2 more weeks after that, if the governor picks a name this week. And we'll schedule that UCCJEA conference. The one of the things I would say though, if immediately on the UCCJEA, it might be either the 2 judges will just analyze the factors. I don't really see this thing going for an evidentiary hearing, but if you check the statute, is there a right to an evidentiary hearing on a forum convenience or inconvenience issue? I know there's a right to an evidentiary hearing on initial custody jurisdiction, but does it apply to forum inconvenience cases?
I don't think so. I think I think we could do it by motion, and I think that the court can make a determination, has wide discretion when it comes to that. When you analyze the factors
Mr. Cleveland
under
doesn't
interest.
want any delays, but if both attorneys will say, let's just let the judges.
My problem with that is we don't know the positions right now, and if there's disputed facts that require evidence, I don't want to say just do it by motion, because then the court's not going to know if there's disputed facts, credibility,
Well,
and other issues like that.
I could just tell you, like, let me give you an example. Well, there are factors under 125A.365, subsection 2, A through H, must like when you do a best interest factor. And there will be arguments, but I doubt it, because one's like, if domestic violence has occurred and is likely to continue in the future, which state could best protect the parties and the child? Well, in that case, there can be a dispute about whether or not domestic violence occurred, but assuming it did, Oregon would be the state to best protect the children because that's where they reside. So you can go through this, and it's like the distance. So
right, but there's a response to that, and that Nevada has the file here and knows what's happened in this case, and there's specific Nevada orders relating to specific therapists that were supposed to be used and psychologists that were supposed to.
There's a lot of history here in Nevada as well, so.
yeah, I gotta get that.
It could be.
I gotta get that stuff.
I'm on the fence on that one, so I don't know, but I'll schedule with the Oregon judge because I do have a case number now.
Thank you.
Lawyers know that when I do schedule it, it is on the judge's schedule. So if you're available or you're not available, most of the time we'll give you as much advance notice. It could be a day, it could be 48 hours. Hey, we got this thing with the judge, and you could appear by blue jeans, and it's going to take place whether you lawyers are available or not. But we will give you as much advance notice that we're going to be on with the judge. Okay. So that I can do. The access to the D case, no problem. Luz will put that standard language in the minutes that Because this is a sealed case, both attorneys will have access to the D case, unfettered access. Ms. Fuji will file the affidavit of indigency forthwith. And let's get a trial date as a backup. If the case stays in Nevada, Ms. Fuji will want.
Oh my God, oh my God, oh my God. Happy birthday, Debbie, and your sister. But definitely you. Happy birthday. I'm so excited it's your birthday.
A reunification type expert and reopen the D case, I suppose.
Well,
I
you know,
don't
it's a yes or no,
know.
so I don't think I will open that, but I would ask for at least 120 days for discovery.
Can you ask for a reunification expert in a TPR case?
Well, what we
It's
do,
real-
what happened in several of my cases is I asked for reunification therapy. The other side opposed it, and the expert then only determined whether or not reunification was feasible. It was a yes or no. Whether or not, after interviewing the children and interviewing the parents, if they believed reunification therapy was even feasible. Once I got past that threshold, then, you know, there was a determination
Who
made. But
normally is the experts on the list?
I use Hope Counseling or I use Red Rock because they have enough therapists for one person to interview the children, another person to interview the parents, each of the parents, and then one third party oversees what happens in that interview and makes a recommendation about whether or not it's feasible. In this case, the kids are a little older, but they're verbal. So it would be someone specialized in that type of, and so those two are the only two that are specialized and accept Medicare. I don't know enough about the parties' backgrounds and history and insurance, but I check with Mr. Fleeman.
How old are the children now?
I think 9 and 12.
Are they testifying? You need a special motion if you do. Okay. So you both are aware of that. April, May.
Yes, sure.
We're early April. April, May, June. That's 90 days. You want trial in July? You want trial in August?
I'd like it in August just because I know with the scheduling order, you know.
It's so freaking weird. Not only is it weird, it's boring. We're watching a very boring Michael McDonald hearing, and that's not right. We didn't pay big bucks to see this.
All right.
And out of state.
Let me get on Odyssey and find out what dates we have August. And if the case stays here, one full day,
That'd be fine, Judge.
Yeah,
I
sure.
think.
we'll hold you to time limits. So Mr. Fleeman's the petitioner. He's got the morning to present his case. Ms. Fuji's got the afternoon. And then exclusive of closings, you're looking at about 3 hours apiece. Mom and dad are the main witnesses. You'll have a reunification expert testify. Who's going to pay for the reunification expert? Obviously not mom and not the court.
I'm hoping the kids have insurance that will cover it. They pretty much, the reason why we utilize Hope or Red Rock,
Okay,
and I'm
work
open
it
to
through-
other people
Work
that
it
it's
through with
covered by
Mr.
insurance.
Fleeman if insurance will take.
Right, they're out of state, so I don't know if it will, but
Okay. And I can't guarantee the new judge will overhaul their calendar, but this is presiding Judge Burton's calendar. She does all day trials on Fridays. Any Friday good with you, counsel, in August?
The first available is August 11th at 9 a.m.
does that work for you? Yeah, it works for me, Judge.
Okay,
It works for me.
very good. You want 30-day status check? I'll just have,
I would like that, Judge, just so that puts an onus on me to get
is
the
30
stuff that
minutes
the court
sufficient?
ordered.
A 30-minute slot sufficient? Because we'll close it out.
Sure.
What do you have?
I have it. We can do May 9th at 9 a.m.
What day of the week?
That's a Tuesday.
And you're gonna block out that 9?
It's nothing set at 9. So do you want?
That'll be the
just
only 9?
That'll be the only 9. I can close
You'll
it.
be the only hour, the 9 o'clock. If you need an hour, but hopefully not.
Terrific.
Okay. I usually don't hesitate to set other cases for that judge to focus on this case. It'll be a status check, but you might see me if I can get with the Oregon judge. It means you better hurry and get your briefings in on UCCJEA, like by the end of the week.
Yeah, I will get that in, Judge. I already started this morning.
Okay.
Can we get a scheduling order for the trial date?
Thank you for reminding me. The JEA will do a TMO, trial management order. If we're going August 11th, August 1st, is that a weekday? Can they have her pretrial memos in? Or August 4th, a week before? What day of the week is? Well, August 11th is a Friday, so August 4th. By Friday, close of business, get your pretrial memos in. You want discovery to close 1 week prior to that, so it'll be 2 weeks before trial, which will be
2 weeks
July-
July 28th.
28th by close of business. Discovery closes. UCCJEA briefs are due by Friday, close of business this week. Or you want Monday? I don't think I can get with a
Well, I
judge
want
that fast.
Monday. I want Monday.
Monday's fine.
Monday, close of business. So we'll make sure the soonest we can get Oregon judge, we'll try for Tuesday. We'll try for Wednesday, maybe Wednesday. Give us a day to read the briefs. Yeah. So JEA somewhere around next Wednesday, which is April 12th.
April 12th. It's a Wednesday, yes. April 12th.
April 12th or thereafter, set UCCJEA. I'll still be here, so I'll probably be getting with the Oregon judge. That'll be a 1 hour setting. Not sure if the Oregon judge has that time of day, but I'm reserving an hour for this because I want the attorneys to argue it. If to get an Oregon attorney, I don't think she would need to. Mr. Fleeman can argue it, and then we'll have that judge on Blue Jeans or however they do it, Zoom. We'll figure it out. I need the name of the name of the court. It would help if you have the name of the court. Mr. McDonald might have that, or the name of the judge. I do have the case number. And it's Yamhill County. How do you spell
it's
that?
YAMHILL.
YAMHI. Yamhill County.
Yes.
And the judge's
And then-
name?
I'm looking for it right now. Mr. McDonald, if you have it.
No, we'll figure it out. As long as we have the case number, we'll figure it out. If you find it, put it in the chat. We're gonna be here in Blue Jeans for a bit, but that's all for
I will
today,
do that.
Counsel.
I'm looking right now. I see a document and I'm trying to open it.
Yeah,
It's from Oregon though, so I can't, he just sent me proof he filed it. I don't have the actual document. He just took a picture.
is that correct? Just want to make sure I have that number.
Did you say, was that the case number you just read off,
Yeah.
Judge? I have case number.
Okay, Yamhill County. We'll locate the judge, and counsel will let you know as soon as possible when we schedule it with the judge, but it won't be any earlier than April 12th. Okay. All right. The temporary JEA, Kimmy Jones, she's gonna schedule all that and send you guys a notice of hearing, notice of UCCJEA here. Make sure you're on the e-service list. Okay, and kind of get those minutes done right away because Miss Fuji she kind of needs access to the DKs. They need a
Okay.
separate minute order from me,
Uh-huh.
so then she could get a printout and then forward it to IT.
He's also good at,
They'll turn
he's a
the
master
For,
For
at
both,
putting
counsel.
for both.
the
Okay.
worm on a
Yeah, I
hook.
don't know.
Make
You
them
have access,
priority.
Mr. Fleeman? We'll make sure you get access to the DKs.
Yeah, I don't currently.
Okay, list the two attorneys. They must have immediate access to the DKs, like today.
Fix your
Okay?
audio, Judge.
All right. Thank you.
Thank you, Your Honor.
Have a good
Thank
day.
you.
Bye-bye.
Mr. Fleeman, call me.
For a long time in this jurisdiction, going way back.
The property that he lists, which we believe is owned by his mother, is a small trailer in the middle of the desert, not far from the other side of Hoover Dam.
Okay, we're on the record. This is a sealed matter. This is case D 23-R in the matter of the parental rights of minor children. We have the plaintiff mother, her Nevada attorney, Jack Fleeman. Your bar number, Mr. Fleeman?
10584, Your Honor.
We have Michael McDonald, the father, with his court-appointed counsel, Valerie Fuji. Your bar number, counsel?
5955, Your Honor.
Okay, and then I'm going to switch to the Oregon case since the judge is on her cell phone. Judge, your case number in the Circuit Court of the State of Oregon, Yamhill County.
Yes, that's correct.
Okay, and you have a Oregon attorney present, the name and his number, bar number?
Good morning, Your Honor. Brent Goodfellow, 033277.
And who do you represent, Mr. Goodfellow? Miss Mother's counsel from Oregon is also present at this hearing. Okay, Judge Easterday, the father filed this case that I announced in the state of Oregon. We have two pending cases in two states now. And so we have to do a UCCJEA child custody jurisdictional discussion. This applies to terminations of parental rights here in the state of Nevada as well. I asked the lawyers in this case to file briefs on the issue. I reviewed the briefs. So, Judge, if it's okay, I'm going to allow counsel. The father is the requesting party. So, Ms. Fuji, you can go first. Please take no more than 5 minutes to argue your case on jurisdiction only.
Thank you, Your Honor. First, I want to make a point that I think is important in this case. My client relocated to White Hills, Arizona, and we filed a notice of change of address on his behalf, April 24, 2023. We are asking Nevada to decline jurisdiction. We understand that Nevada has initial jurisdiction because of the custody order in this case under NRS 125A.305. But we believe that Nevada is an inconvenient forum under NRS 125A.365. There are simultaneous proceedings that are happening right now. And if Nevada were to decline jurisdiction, we'd like the matter to go forward in Oregon under NRS 125A.365, subsection 3. So he's already filed a motion for custody. He has requirements that the last order here in Nevada would require him to comply with prior to visitation. We're still fairly young, Your Honor. The factors that I set forth in the brief carry even further. What I think is important for its indulgence. As to the which is the preference, is that currently there are no ties to the state of Nevada. The children, the parents, none of them reside in Nevada any longer. The fact my client has a DV conviction first from a while back is public knowledge. His incarceration is public knowledge by judgment of conviction, either state, and certainly this is information, public information that is easily accessible to Oregon. What is important is which state would be best able to protect the children in this case. It is foreseen that the visitation would all occur in Oregon. It would all occur if the children want therapeutic intervention or they would like some sort of therapy involved with visitation with their father, that would occur in Oregon. The state best able to protect these children is Oregon. CPS Oregon would be who would respond quickest for these children if there were any allegations of abuse. Law enforcement in Oregon would be the better suited individuals to handle any claims by that can get to the children quicker. These children have been in Oregon for almost 2.5 years. My client got out of custody, I believe in May 2022, released honorably discharged from probation in February of 2023. Since that time, he has received a psychological assessment from a PhD that indicates he is no longer a harm to anybody, or he was never a harm, but he is not a harm to his children, that reunification efforts should begin in Oregon. That is something I am not a part of those filings, but he is indigent. Otherwise, I would not be here. I filed his financial disclosure form pursuant to the court's request and opposing counsel. He would qualify for the same type of services, but a termination of parental rights, we know, Your Honor, is a heightened standard by clear and convincing evidence. He would qualify in Oregon for that court-appointed counsel. But prior to terminating his rights, reasonable efforts are going to have to be made in the state of Oregon to see if, in fact, he just wants a relationship with his children. So we're asking this court to decline or stay jurisdiction so the matter can proceed in Oregon and he can get a relationship with his kids.
Okay, thank you. We'll turn it over to the Mother's Counsel, Jack Fleeman, to make their arguments.
Thank you, Your Honor. There's a long history of cases in Nevada between these parties. There's a divorce, there's protective orders, there were criminal proceedings where Mr. McDonald was convicted, spent time in prison for felonies in Nevada. There are very specific court-ordered requirements in Nevada that require specific people to do psychological evaluations. Ms. Fuji's coming in here and saying he's had these psychological evaluations. There's zero evidence of that anywhere. He did not have the psychological evaluations that he was supposed to have. He submitted to this court psychological evaluations that predate the prior court orders that the court already considered. He was convicted of perjury, forgery in Nevada, in the Nevada divorce, related to the Nevada divorce case. The specific act of forgery was forging a document that said he was not a danger to the children. And that's our concern. If this goes up to Oregon instead of Nevada, you know, there's a lot of these things that he's going to continue to play the hide the ball game and try to deceive the Oregon court like he did the Nevada court. He has stated plainly in this case that he thinks that the Nevada court system has been out to get him. So that's why he's forum shopping. He wants to get out of Nevada. I'll get to his alleged move in a minute, but in terms of the Oregon case, my client's never been served. The order that he registered in Oregon is not the most recent order, doesn't even include the specifics of the psychological testing that he's supposed to have. And, you know, the Nevada court has the access to all those records. My client would have to dig back through years and years just to keep producing things to the Oregon court that the Nevada court can look at immediately.
Is he though? Is he
moving the case to Oregon simply gives him an excuse to travel to Oregon when he has no contact pursuant to the court orders. The transfer would just delay the case because there's already a trial set in this case. It's really a bad faith attempt right now to divest Nevada of jurisdiction. We filed this case and now he moves to Arizona. The property that he lists, which we believe is owned by his mother, is a small trailer in the middle of the desert, not far from the other side of Hoover Dam. So he's moved out into the middle of nowhere in a trailer, supposedly, where there's no stores, there's no work, there's nothing out there. So he wants this court to say, oh, well, no one's in Nevada anymore. If we allowed that to happen, anytime a case was filed and this type of thing was going forward, a party could just move out of state and, oh, now the court has to divest itself of jurisdiction. That's not how it works. He was a resident from 2015 when the divorce was filed all the way through the beginning of this case, and now he's suddenly out of state. I don't know that I've seen the financial disclosure form that was filed saying that he's indigent. I believe he had a job when this case started, and unless he's quit that job and just moved out into the desert, supposedly. So, you know, we're asking.
I missed it. I'm so sorry. Thank you so much. Thank you.
This court for Nevada to keep jurisdiction. We're asking if the court is inclined to believe that he may have moved out of state and that's a reason to move jurisdiction, we would ask for an evidentiary hearing on the fact that he's probably not actually moved out of state. Again, I don't think that's very relevant because I think he was a resident at all times that were important. And with that, Your Honor, I'll submit that I think Nevada should keep jurisdiction.
Okay, Ms. Fuji, I don't know if you want to do a 1-minute rebuttal.
Briefly, Your Honor, I think what's important to focus on here truly is the parent with all the information regarding the children's well-being, their health, education, and otherwise is in the state of Oregon, where they've been for
Probably 3 years later, like I'm pretty sure, because this is May 5th, 2023.
over 2.5 years. If the children need counseling, reunification therapy, all this would take place in Oregon. Doesn't matter if he's in Nevada or Arizona, he would be required to travel. Think about it. He doesn't get a free counsel. I was court appointed by this court. I'm on this indigent defense panel, specialized in termination of parental rights, which is a much higher standard. This client was instructed, pursuant to the last orders of the Nevada court, upon his release, to get a psychological assessment and to apply for custody. And that's what he's done in Oregon, where the kids are. It's far more convenient for him. You have to ask yourself, why does mom want them to be in Nevada? It's because mom has significant ties. It is unique. We can't kid ourselves. This guy ran for assemblyman, and because he submitted or filed a false document in family court, he got the first conviction I've ever heard of for a felony burglary for entering family court and filing a false document. Mom works for used to work for a law firm in Nevada, has significant ties to Nevada. Mr. McDonald could not get a job in Nevada because of his convictions and the ties that these parties have, both of them with, law enforcement in Nevada. All he wants to do is see his children. When you look at the factors under the form nonconvenience, and you look at the fact that he is residing in Arizona. I asked him, do you have a place to live there? Yes. You're working there. I do not know, but I can tell you, he's giving up, me in a way, and he would not get free counsel in a divorce or custody proceeding. He only gets that, at least in Nevada, and I believe it would apply in Oregon, if someone's moving to terminate his parental rights. So there's a huge advantage, and she already has counsel there.
Okay. I don't know if you had wanted to say something else, Mr. Fleeman.
The only thing I want to say is that, the court order is not a general order that he just get a psychological evaluation. There's 2 very specific psychologists that were listed in that order that he's supposed to get. He can shake his head. He's been shaking his head the whole time, as the court should note for the record. The psychologists are Dr. Holland or Dr. Bergquist, and those are the 2. And he filed an order in Oregon that is not the most recent Nevada order because he doesn't want the Oregon court to see what he's required to do. In terms of getting custody in Oregon, he hasn't seen these kids in 6 years. He has had no contact in 6 years, and there's a reason for that. And the evidence and everything that's ever been in front of the court is all in Nevada, and he's just trying to form shop because he doesn't believe in the Nevada court system. He thinks that he was railroaded somehow, and he doesn't take responsibility despite what he said in his parole hearings. Now he goes back to his old ways of saying it's all the court's fault. It's all fault. Nothing is his fault, Your Honor.
And if I just may, in response
briefly.
to clarify.
Yeah.
Thank you. So if they're going to demand that this man who qualified for indigent defense panel pay for $5,000 to get an assessment with specific people in Nevada, that is a fight that will happen later on down the road. But be acutely aware of it. The goal here is for him to have contact with his children, not to put in roadblocks or restrictions of someone who qualifies as indigent by having to get a very expensive psychological with people who I don't even know are still practicing with practitioners.
Okay.
They're both practicing.
Okay, let's go with Mr. Goodfellow, the Oregon attorney representing the mother, if he has any arguments for the judges.
No, Your Honor, I got nothing to add. Stand on what Mr. Freeman said.
All right. Judge Easterday, do you have any comments or questions? I would proceed with my legal analysis of our Nevada statute, chapter NRS, Nevada Revised Statutes, chapter 125A, which is our UCCJEA, which should be substantially similar, if not identical, because all 50 states follow the UCCJEA. Do you have anything, any concerns or questions?
I just, when I was looking at this case yesterday, which I'm glad I did because our computers are not working right now, but when I looked at the Oregon case that Mr. McDonald filed, the only thing I saw that was actually filed was the, request for the registration of the foreign judgment. I did not see any motion to modify that was actually admitted into the Odyssey system. Unless I didn't see something correct, the only thing is that
Take a deep breath. I got mentally down. I just want to see my kids. Come on. I've done nothing.
Mike, please calm down. Dude, take a deep breath.
Guys, come on. You're gonna really throw me in jail because I missed my kids. Come on.
Assistance in 15 Charlie. 15 Charlie.
Stop. Come on, please, guys. Please, I don't want to.
You got it?
Yes. Let's just hold him. Come on.
Mike,
All right.
fighting with the guys.
Wait, I'm gonna take her.
Mike, stop fighting with them. They're helping with cuffs on you. Don't
Do you
fight with them.
understand? I'm gonna
Don't
tase
fight.
you.
Don't fight with them. With the handcuffs on. Mike, put the fucking handcuffs on. Or I'll put them on myself.
Great, come on.
I'm on your side, Mike. Put you out of line.
This is ridiculous. There was no order saying I can't send my kids to steal everything.
Mike, just relax. Deep breath. Mike, take a deep breath.
I got mentally down. I just want to see my kids. Come on.
request to register the foreign judgment, and we only got proof of service, I think it was last week, that it was served on through a law office. So maybe people could, I don't have a motion to modify pending in Oregon court. Am I misunderstanding?
Okay, so the question is, does a registration of a foreign judgment in Oregon satisfy the definition of proceeding, a custody proceeding? If you register a foreign judgment, you could just do it to enforce the foreign judgment, but do we have an actual viable custody proceeding in the state of Oregon? Does any of the lawyers want to kind of jump in on that one?
I mean, I can speak to it a little bit, Your Honor. My understanding is that my client, well, first of all, my client's never been served. Mr. McDonald hand-delivered paperwork to my office. We did not accept service on our behalf for anything in the state of Oregon. Ms. Fuji was already aware of that, but I don't know that my client's ever been served. To my knowledge, she hasn't, and I don't think she's ever been served with a motion or anything of that sort either.
And I defer to my client and ask. I know that he forwarded me a petition for custody and parenting time in the 25th Circuit for Oregon for Yamhill County. I would defer to him whether or not that was actually filed. We do know that Ms. address is kept sealed and confidential for Mr. McDonald, so he would be required to serve either via publication. He served current counsel who refused to accept service, but I don't know what attempts he made, and I did not prepare, draft, or assist with that filing, so I just asked him.
Okay. I have an affidavit in support of registration of the foreign judgment. That's all I think that, and that the judge saw, and I think they have, we use the same system, Odyssey. At any rate, let's keep it simple, okay? Our NRS 125A.055 defines child custody proceeding as any proceeding in which legal custody, physical custody, or visitation with respect to a child is at issue. It includes divorce, separation, neglect, abuse, dependency, guardianship, paternity, and in this case, termination of parental rights and protection from domestic violence in which the issue may appear. The term does not include juvenile delinquency, contractual emancipation, or enforcement pursuant to 125A.405 to 585 inclusive. And so what we have is just a petition for registration for enforcement purposes. I do not believe
that the definition of child custody proceeding has been satisfied. Now, if Mr. McDonald is going to file additional stuff in Oregon, then that may change the legal analysis, the approach. So as it
So, Your Honor, I
stands-
think both,
Yeah.
I think both parties agree that he did submit it. Ms. She talked to the court clerk and that it was submitted but rejected. Mr. McDonald, this is all in our group chat. Mr. McDonald indicated that he filed it because the court rejected it, or the clerk, I don't know, because they wanted to hear this UCC JEA hearing first.
Well, I don't feel assured here that there is an actual proceeding in Oregon, just the registration of a foreign judgment, which that may shorten things today, because I know that Mr. McDonald and his may file in Oregon to initiate a proceeding, and then we're going to be back to where we are arguing. The other alternative, Judge Easterday, is to try to do the legal analysis, but are we putting the cart before the horse? I think we should make Mr. McDonald file a proceeding there, which means a request for visitation or something, or custody, which then we could continue this conversation. If you feel like you want me to do a legal analysis on, hypothetically, if Mr. McDonald is going to file that proceeding, then we're gonna be back here again anyway to argue it. So how do you feel about that, Judge Easterday?
Yeah. I guess my thought is, and I haven't done a registration for a while, but my memory is that, the registration is filed, the other side needs to be served, they can object. We actually have a hearing whether it should even be registered in the state of Oregon, and usually that's for the purposes of enforcing court-ordered parenting time and things like that. So I would agree that we're not quite there yet. And my understanding is they would have rejected the motion to modify because the registration piece hadn't been, resolved. I hesitate to do an analysis on something that might happen in the future, just because circumstances may be different in a few months. So that would be my only thought on that. And it sounds like you already have a trial date on your petition to, terminate. So that case is proceeding as we speak. Those are some of my thoughts.
That seems fair. But I just want the court to be aware.
Yeah.
I would instruct him to serve Brent Goodfellow, who is her counsel on the record in Oregon. So now he has someone to serve because her address is confidential. And I do think we'll probably be back here before our TPR trial date doing this UCC JEA. But it might not be right today based upon what your honors are stating.
Yeah, and I don't know. We follow e-service here, and if they use Tyler Odyssey, it's the same thing. You can log on and then create account, log on, and then add your email addresses on e-service if Oregon rules, court rules permit that. But neither here nor there. Judge, I absolutely concur with you. I'm not in any disagreement with anything that's said today. We're kind of putting the cart before the horse because we don't have a custody. My finding today is under the definition 125A.055, we don't meet the definition of child custody proceeding. And Judge Easterday, I just wanted to let you know, this case has a very long history. In fact, I retired 2 years ago. I'm just a senior judge covering in Department C. I was in Department I. This was a Department I case years ago. It came from another judge. And then the final orders were made, and then a few criminal cases, contempt proceedings happened along the way. And so there's a lot of things filed. So Mr. Fleeman is kind of accurate in describing that. I don't recall Mr. Fleeman. I think he just entered the case, but he wasn't on. None of the lawyers on this case have been part of the history of when I was an active judge in Department I. And then somehow it got randomly assigned and ended up here in Department C. The new judge is taking the bench on May 15th, Judge Gregory Gordon. So I may have to kind of fill him in because it sounds like there's another proceeding coming down the road, another UCC JEA proceeding. I would just want to throw my 2 cents in there before I
go back into retirement status after the end of next week. If my understanding is if I have two parents no longer living in Nevada, okay, then Nevada loses jurisdiction on child custody jurisdiction. So what happens to the fact that Nevada would lose jurisdiction? Well, then you're looking to the state of Oregon to see if they have initial child custody jurisdiction, which the kids and mom have been in that state for, is it 6 years, Mr. Fleeman? At least several years.
It's a little over 2 years.
A little over 2 years. Okay, thanks for letting us know. That's clearly, the kids have been there a little over 2 years. That's clearly over 6 months. If I don't have two parents in the same state, the court can't exercise jurisdiction. Now, there is a statute here that addresses simultaneous proceedings, but can it be simultaneous if I don't have two parents in the same state of Nevada? It may or may not apply. So this is just food for thought. And then you have 125A.375. Could a state decline jurisdiction because of conduct of a parent? You know, is conduct forum shopping? I don't know. Is conduct involving some type of domestic violence? We need to look further into 125A.375. That's all I have to say on that, those operating statutes. But the first observation I would make is I see it coming down the road. If Mr. McDonald files and initiates a child custody proceeding over there, if Judge Easterday determines that that meets the definition, we follow the same UCCJEA in as between the two states. It's something to anticipate. So at this point right now, Nevada will keep jurisdiction because the Nevada court finds that under 125A.055, it doesn't meet the definition of child custody proceeding. He registered the foreign judgment. I think that they have to get past that step or file something else simultaneous in Judge Easterday's court, like a motion or petition for visitation or a modification of custody. Okay, so what would be the next step? Well, Oregon doesn't have to do anything at this point. Nevada's keeping jurisdiction, and then until Mr. McDonald files proof of a child custody proceeding in Oregon, the analysis here is that even though I don't have two parents in the same state, you know, by law, pursuant to statute, I have to keep the case open because there is no other state where the proceeding can be heard. Even if I don't have two parents here in Nevada presently, there is no other state because we don't have simultaneous proceedings. Okay. And also, yes, the long history and the various cases that have occurred here in Nevada. It's coming. So Judge,
may I ask?
Judge Easterday, I will serve you a copy of the court minutes from today, and I think the minutes will suffice. Finding, no parent lives in Nevada. Second finding, no other state has a proceeding, and so Nevada will keep it. Number three, if Mr. McDonald files a proceeding, then the two judges will get together, and it won't be me, it will be the new judge, Judge Gregory Gordon.
Your Honor, with regard to that finding,
Judge, the only thing that I guess I would inquire about is there's only been an oral representation that the father has moved. I don't know about this finding of fact. That's just my thoughts, Judge.
And that was what I was going to say, Your Honor. We have no evidence that he moved. We do have years of perjury and everything else to the court. His moving is very, very convenient. It was after the case was filed. He's lived here for many, many, many years.
I appreciate counsel's argument.
Freeman. So
he has indicated to me it's a 3-bedroom, 2-bath house in Arizona on 2 acres.
Does he have a job in Arizona? Does he have an Arizona driver's license now?
These are good questions, Judge.
I will
Yes, I do, Judge.
I will.
And Judge, can we please clarify with the Judge Easterday? I tried to file the motion for modification
Hang on,
of
Mr.
custody.
McDonald. I'm on this issue of your residency. Counsel, I will open discovery on the residency issue. Mr. Fleeman, you could serve discovery on Miss Fuji and gather information. Okay. Does that affect my ruling today that he moved out of state? No. If he was still a Nevada resident and I find that, Nevada keeps the case, at least for now. If I assume that he is an Arizona resident, we don't have another proceeding in another state. So I think you both understand that, but I'll open discovery on that.
Thank you. My client is chomping at the bit because I guess he has made numerous attempts to try and file the pleadings. I guess my specific question is, does Oregon, and I would defer this to Judge Easterday, does Oregon require e-service, the parties for e-service to log on and put their name on the e-service list so they can be served? Because Mr. McDonald, because her address is confidential by order of this court, to effectuate service. I believe that's what he's trying to ask.
Yes, good question.
I can't answer that. I don't know off the top of my head, but the rules are on that.
Yeah, I think you can inquire. You could maybe inquire with an Oregon attorney. That's what he should do.
Yes,
inquire
I will defer
with an
him
Oregon
to that, Your Honor.
attorney. Okay.
I will defer him to that.
Judge, I don't have his
you're
information.
You're not in the dark, Miss Fuji. We have NRCP Rule 4 on service of process, but he needs to follow Oregon rules of service of process, which is you're not licensed in Oregon. He has to talk to an Oregon lawyer. Mr. Fleeman, you have a question? Oh, okay. Mr. McDonald, do you have a question?
Yes, Judge, I have a couple of questions. I did serve a motion for a change of address. I have an Arizona driver's license out here. I do reside here. I have a rental contract out here. I also want to reinstate that I've tried several times to file the motion in Oregon, but there was some kind of hearing from the family court judge in Nevada. I don't know if that was you or not, that called Oregon and said that there has to be this hearing before I can file anything there. So I've tried several times to do it. It keeps getting rejected. I filed every detail that the first couple of times I didn't have all the motion set up correctly. So if we could established that with Judge Easterday and just say, hey, can I file it, and that they'll actually accept it, that's what I'd like the court to.
I don't know if they have e-filing. It normally you're able to e-file like we do here in Nevada. But
it was rejected due to this hearing today. So
excuse me. I'm not gonna. I have to look up the rules just like everybody else. I'm not gonna say that. I do have a 10 o'clock hearing. I was told this was only going to last 20 minutes. Am I needed anymore?
No, Judge. Thank you so much for your time and logging on.
Okay, you're welcome. Thank you.
Thank you.
Thank you, Your Honor.
Okay. All right.
Okay, bye-bye.
Bye-bye.
Thank you.
Okay, so logistically, counsel will issue some court minutes. I'll serve it on the judge. It'll be, you'll have the court minutes. And then you would know how to proceed accordingly. I think Mr. McDonald's question here is logistics. And I can't speak to Oregon rules and logistics. And what he's saying is that whatever he's trying to file is being rejected. Please consult with an Oregon counsel or attorney or some kind of self-help center there in Oregon.
I'll talk to him about it, Your Honor. And
you are a very resourceful lawyer. So I think you can help him get to some resources in Oregon to the best of your ability, because you're not licensed to practice in Oregon, I take it. Okay.
No, Your Honor, but
very
I'm not, but
good.
I will.
Okay, we'll issue the court minutes, and I've recapped what I said, so it'll be in the court minutes.
Thank you, Your Honor.
Have a good day. Have a wonderful day.
Thank you.
Thank you.
For a long time.
All right, this is case D23R. It's a sealed matter in the matter of the parental rights of appearances for the record, please, beginning with petitioner's counsel.
Good morning, Your Honor. Jack Freeman, bar number 10584, on behalf of the petitioner who is present via Blue Jean. She lives in Oregon.
Good morning, counsel.
Good morning, Honor. Val Fuji, bar number 5955, on behalf of the respondent, Michael McDonald, who is also present via Blue Jean. Michael, if you could turn your video on, please.
All right, you can be seated, counsel. All right, we're on calendar today on two matters. One is the petitioner's motion for a summary judgment on the issue of jurisdiction, and the other is the respondent's motion, and since filed amended motion to continue the trial date. Let's talk about the trial date first. Let me begin by telling you the court needs to do a little bit of trial calendaring maintenance here. Unfortunately, I'm double booked on the day that we're set. When I inherited this calendar, they had dropped a bunch of cases into it from other departments, and so I have cases all over the place. So I do need to do a little bit of maintenance, and it will result in us pushing the trial back probably to the beginning of the year. But I do want to have a discussion with you both about this evaluation, because I mean, has any progress been made, Ms. Fuji? I mean, has anyone even?
Oh no, he got me so excited. He said this evaluation, and I thought he finally got a mental health evaluation. Oh, he didn't. He didn't.
Evaluator even been selected? Because I know what's going on in this community as far as getting an evaluator pinned down and get them available to do work is challenging right now.
In response to your question, Judge, it has been hard. But I will say the county's been gracious, understands the gravity of this proceeding being a termination. And I have an appointment on Thursday at 1:30. That's the 28th of September with Dana Anderson. She is a California psychologist recommended by. So at least I've got potential. I also reached out to DFS Clinical. They do evaluations for 432B cases and delinquency cases. She gave me a list of providers that are not Clark County. They're not employed by DFS Clinical, but they do have the credentials that's necessary in compliance with the custody orders to do the evaluation. And I will reach out to them. I think I'm gonna have to call. I was sending this blanket email, Judge, like, hey, let me tell you a little bit about the case. And then I think what happens is if Mr. Fleeman's office gets a hold of them, you know, unfortunately, there's a tormented history. I see it as a simpler case, I think, but I think it's very important that they get their opportunity to unload the history, both criminal and civilly, on this psychological assessor, so we can get a full evaluation. But truly, it's necessary because we were asking for cards and letters, some sort of contact, and that appears to be barred by the custody court decision until this evaluation is done.
And that condition of that order was put in place a long time ago, right? I mean,
yeah, it's so weird. So in the D15, the order from July 3rd, 2019 and December 7th, 2020, my client was incarcerated at the time. First, it said we needed someone with a PSY or PhD to see if he's a danger or harm to the children. Then the subsequent order in December 7th said it has to be either Berquist or Holland, which I thought, wow, okay. So I reached out. I got a hold of Berquist. I got a hold of Holland. Both declined to accept the appointment. So then I just looked for anybody with a PSY or PhD. At that point, Mr. Fleeman got in touch with me. He had been involved since the inception of the custody case, I believe, and we formulated a stipulation and order of what the scope of this assessor would be. That was filed in this case on July 25th, 2023. And now we just need a mental health evaluation of respondent for the sole purpose of assisting the court in determining if there's any physical, emotional, or mental risk that respondent presents to the children. It's not to determine whether or not
I saw
his rights should be
I
terminated.
saw that, Ms. Fuji. I mean, here's the issue I'm having in several cases now is that the parties agree in principle to have this done, or the court sets it as a condition, and then it's becoming like near impossible to get them actually
Right.
done, right? And it's stalling these cases. And I mean, I do see, and I've saw the stipulation, and I do see how that is beneficial. It could be beneficial to the court to have some information and some input regarding the risk factors, right? I mean, we're not getting an opinion regarding best interest. We're not getting an opinion regarding termination, but if I'm getting some information and some input regarding, psychological, emotional, mental type risk factors, then that would be very beneficial. So I need to move this trial regardless of the request and that came in. And so my question really is, if I move it to sometime in late January or early February, is that even a realistic date? That's what I'm concerned about. Sure. And I know
I'm hoping, Judge.
Hold on, Ms.
Yeah.
Fuji. And I know your client is anxious and wants to have this matter heard. I understand that. I'm trying to, obviously have to balance. You guys, we did set in motion this process of getting the evaluation. So I don't want to short circuit it or cut it off right midstream.
Can I bring 3 things up, please?
Hold on, Michael, we'll get an opportunity to talk.
Sure.
The 2 evals done and jurisdiction and.
Sir,
Michael, we'll get an opportunity to talk.
Sure. So I don't have a problem with the continuance of the trial. I think I said that in the opposition. In terms of the evaluation, it's not something from our point of view that we think must be done, but we do agree that it can be done, and that in the custody case, which is closed, it is a requirement. Our issue in this case, and I would like to make a little bit of a record, is Ms. Fuji said that she believes that I'm contacting these people, giving the history of the case, which hasn't happened. I know the court doesn't really care too much about that, but for the record, I've contacted anyone giving the history of the case. Ms. Holland, or Dr. Holland, did take the case, and then she later said, no, I don't want it. I don't know what happened there. It is required by the custody case that the evaluation that my client is involved and able to give information, and that the evaluator has access to the record. So that was part of what we put in the stipulation in order. So right now, I understand the court's quandary of when do we put this, because I don't know if January or February is going to be. That's probably too soon, because we're coming up on winter fairly soon. These take at least 90 days or so sometimes.
That's what I'm concerned about. And
I gave the California Dana Anderson name to Ms. Fuji a couple months ago, I think. And this is the first time I'm hearing that it's being looked into. I think she already told my client that she can do the evaluation, so I don't think it'll be a problem, but I don't know how this court is going to set a trial date based on that. I think I don't know how we set a date today, honestly, and I think February is probably too soon.
Yeah. So you're thinking more of a status check to make sure that we are at least working towards a conclusion of that evaluation before we set a trial date. And listen, my trial date, beginning January on, is wide open. So if we set a status check at the beginning of the year, and we learn at that point that we're making good progress, or it's either concluded or it's about to conclude, then I'm sure we can get a trial date on it the 60 days after that. So that's your, so I understand. Okay. So that's your client's position. So did you hear that, Ms. Fuji? So Mr. Fleeman is sort of saying is, let's just set a status check at the beginning of the year. But your client, you need to be diligent in moving forward with this, because because if we come in the beginning of January and there's no real progress having been made for whatever reason, at some point we do have to move on, right?
That's correct. So it's unfortunate, but the way it was written was he cannot even send a card or a letter or a birthday card until this assessment is done, essentially terminating his parental rights.
Yeah.
So he has been denied all contact. Generally, I would have been requesting reunification therapy. I would have been, because of his absence, I would have been requesting contact, phone, video, but none of that can be achieved till because of the orders in the custody case. So
we'll talk about that
deadline for the expert is October 16th. And we're going to miss that deadline, obviously. We are at the mercy. I tried somebody in state, and then I tried somebody that would be approved by the county. So it wouldn't cost.
I understand the challenge that you're facing, and I get that. So we're going to set a status check at the beginning of January.
Tyler, can you bring up that there was an eval done in April? Like there was a brief focus.
Yes, Michael, I will do that.
So I did
will,
my due
Michael.
diligence
Just
in
hold
trying
on,
to
hold
fulfill
on.
requirements.
Let me do it.
This
I think
is
the judge
denial of parental
understands that.
rights
Hold on,
by
Michael,
Myers
hold on.
versus
Could
Nebraska.
we mute my client, please? So, Your Honor, there was an assessment done by Phil Colosimo the day he got out of, incarceration. Then he was on P&P, parole and probation, and he was honorably discharged on April 16th, I think, of 2022. At that time, he underwent a psychological assessment with Phil Colosimo.
Hold on, Ms. Fuji. I know, understand. And just to keep, and you'll advise your client after today that what we're here on today is a petition to terminate his parental rights. I mean, this is not, we're not on calendar day on the custody case.
Correct.
Divorce action. Do we have a date in the second week of January?
Yes. Status check January 9th at 10 a.m.
Does that work for you, Mr. Fleeman? Ms. Fuji, does that date work for you?
Yes, Your Honor.
What'd you say, January 10th?
Can you bring up there's also a court date? Oregon.
Michael, that's a different motion. We'll argue next.
Yes. All right. So we'll have status check then. We'll check in with you at that time, Ms. Fuji, to see, hopefully we'll be able to set a trial date at that time. The trial date that's currently set for December 18th is vacated, as well as the calendar call set for December 5th. Okay, let's turn to the motion for summary judgment.
Can we get a new scheduling order, Judge, too? Well, I guess we can't until we come back on the status, can we?
Yeah, I mean, essentially the discovery dates have all been extended by virtue of.
Yeah, and I will let the court know that we have exchanged written discovery and we've also deposed both parties.
Okay. All right. Turning to the motion for summary judgment, Mr. Fleeman.
Yes, Your Honor. As Ms. Fuji mentioned, we've conducted discovery. It's still ongoing. We both deposed each other's clients. The issue is that even at the deposition, and Mr. McDonald is asserting that this court doesn't have jurisdiction over him, that there's no custody jurisdiction. The fact is that this case was filed in January, it was served February 2nd. He then relocated, he says, to Arizona in mid-April. The date I think he has now is April 18th, the most recent discovery that I've seen. His position is, since I've moved to Arizona, this court no longer has jurisdiction. Our position is, it's at the time of the commencement of the action. It doesn't, that's under the UCCJA, but even a practical matter, if parties could just leave the state and then the court loses jurisdiction, it would be mayhem. He has filed in the state of Oregon previously. He filed the wrong order. He filed an old order. That case was dismissed. Now that we filed for a summary judgment on the jurisdiction issue, and to be clear, I'm not saying that Nevada has made any determination that it's a more convenient form or any of that stuff. What I'm saying is this state has jurisdiction, has continuing exclusive jurisdiction over custody matters, which under the UCCJA, the termination case is a custody matter technically. So he has now filed again since we filed our motion for summary judgment in the state of Oregon.
Oh, he has filed in Oregon.
Yeah, he filed in Oregon. I think there is a hearing on the 4th, but I don't think it has anything to do with, I think it's his motion for reconsideration. I don't think it has anything to do with the substance of the case or the UCCJA or anything like that.
On the 4th of October.
I believe it's October.
To reconsider did they deny the registration of some sort? Is that what it is?
I believe they dismissed the case on the basis that he didn't register a proper order. But
Okay.
I mean, he would know a little bit more about that. That's my understanding through my client.
Okay. Okay. All right.
Thank you, Your Honors. So I thought this issue might be a little bit.
I'll come back to you, Mr. Flynn. Go ahead, Ms. Fuji. I'm sorry. Go ahead.
No problem. Thank you, Your Honor. So Nevada obviously made the initial custody order pursuant to NRS 125A305. But this court has the jurisdiction to modify that under 125A325. Initially, I made the argument there was a simultaneous proceeding in Yamhill County under 125A355. And we had a kind of semi-UCCJEA discussion with Judge Moss and Judge Easterday from Yamhill County. And at that time, the court made some determinations. And I quoted this in my opposition, because I think this is key. Under NRS 125A315 subsection 1B, that a court of this state or a court of another state will lose that jurisdiction once they determine the child and the child's parents or any person acting as the parent do not presently reside in this state. So when we had this hearing on May 5th, 2023, Judge Moss made.
I understand Twitch just went down. It's fine. I think it's up again. It might not be, but it's fine. It's fine.
It's an interesting discussion. She allowed petitioner to do some discovery because they argued he purposely moved out of Nevada to lose jurisdiction. So the court allotted them the opportunity to conduct discovery on it, and they have. But my argument under the Carr case and under the Johnson case is once it's determined that the child and the child's parents no longer reside in Nevada, the district court does lose exclusive continuing jurisdiction. In addition, the extra argument is it's an inconvenient form pursuant to NRS 125A.365. And my extra argument is that there's a simultaneous proceeding. So what happened was Michael initially had filed a foreign judgment, used the wrong order, the last order from the court in Nevada he did not use. So since that time, he has refiled correctly the pleadings necessary in Oregon and has a hearing on October 4th, 2023 in Yamhill County. So here's what I can tell you. He provided a lease, he provided a driver's license, he provided a utility bill. These are part of our 16-2 production that will be exhibits before the court. He was deposed, as was deposed, and she has been with the children in the state of Oregon since December 2020. And what I foresee, what I hope to foresee, judges, if they're so worried about, respondent, if something happens visitation wise, who would respond? Well, it would be the people in Oregon. It would be the school in Oregon. Visitation most likely would take place in Oregon. As much as I love to do this, I think Mr. Fleetman would agree. The best way to go forward with and the children live in Oregon and Michael lives in Arizona would be to have Oregon have this case. There's already a proceeding that will move forward October 4th in Oregon, especially when this court makes the findings, and that's what I'm asking, and that no party presently resides in Nevada, and therefore Nevada's exclusive continuing jurisdiction ceases under the statute in the Carr case.
All right. Thank you, Ms. Fuji.
Your Honor, if I may, I don't know if you want to say something, but
No, go ahead.
In terms of the Carr case, I think that reliance on that case is misplaced. In that case, the father filed after he had moved. And the court made it clear. It said you filed 2 months after Kathleen was named the mom and the children left Nevada. By that time, you were already living in Turkey. So nobody was in the state at the time of filing, and that was the date that was important. In terms of where he lives, I think that is an evidentiary issue potentially because the discovery was not open to whether he purposely moved. It's whether he moved at all. And we've included a lot of exhibits to show he's in Nevada many, many times on a weekly basis. He's alleged to be living in a trailer just the other side of Hoover Dam, essentially. He produced a rental agreement with his mom. He testified that he doesn't actually pay anything. He kind of just does chores around. But we have no bank statement showing any of that sort of thing. So,
Let me stop you there because from the court's perspective, and I'll give you the benefit of my analysis because I'm not sure that it really matters all that much for these reasons. I think that the petitioner is correct that for purposes of determining continuing exclusive jurisdiction under the Friedman case, the analysis is assessed at the time that the petition or that the motion is filed. Here, the petition was filed back in January of 2023, the petition to terminate parental rights. And there's no dispute that at that time, the defendant was residing in Las Vegas. In fact, he makes that admission or that acknowledgement in his UCC JEA brief that I think he filed in April before that of 2023, before that last conference. It's right there in black and white, his acknowledgement that he was residing in Clark County. And so there's no doubt that when this petition was filed, this petition to terminate parental rights, that at least one party was residing in Nevada and that Nevada had continuing exclusive jurisdiction. I don't know that we have a case in Nevada that says that the court then retains jurisdiction until the conclusion of that proceeding. I think that there are other jurisdictions that have said that. In other words, there's a case law in other jurisdictions that have confirmed that once that assessment is made, continuing exclusive jurisdiction is deemed established, that the jurisdiction retains its hold until the conclusion of that proceeding. So if someone does move away during the proceeding, that's not necessarily going to divest the court of jurisdiction. So I'm satisfied that when this petition was filed, that Nevada had continuing exclusive jurisdiction. For me, and I'm not sure that his residence today matters all that much, at least not for that analysis. And we don't have a case in Nevada that defines what residence means, right? Does it just mean physical presence? Does it mean more than that, right? We don't know. And it sounds like there's some disputed issues there. I will tell you that the issue that I'm more struggling with is the one of the inconvenient form. And I think that the parties did sort of tee that up a little bit for Judge Moss back in May, but I think it all kind of fell flat because there was no proceeding in Oregon. Does that make sense? And there doesn't need to be a proceeding in Oregon for the court to find that it's an inconvenient form. But as I'm sitting here today, I can tell you what the court's concerns are. I mean, if the defendant has moved out of the state or across the state line by a few miles, and the plaintiff and the children have been in Oregon for now 3 years, going on 4, the state of Nevada is bearing the cost of the defendant's defense in this case, the therapist, and so forth. But here's my big concern, and Mr. Fleeman, this is to your
You're not paying enough.
If the defendant does register whatever the last custody order, the correct last custody order in Oregon, and if he files a motion to modify that order, right? I think that this court would now be in a position where if there's a new motion filed, right, the continuing exclusive jurisdiction analysis assessed today would be different, right? If he can persuade the court that he's residing out of state, right? Different today than it was in January when she filed her petition. I mean, potentially we could have cases going in 2 different states. That's what my concern is. We could potentially have the petition for to terminate parental rights here because it was filed in January, right? But a motion to modify custody may very well have to be filed in Oregon and can be filed in Oregon. Does that make sense? And so then it begs the question of, then I think we'll get to another UCCJA conference, and we get to the question of inconvenient form. I think what the court is struggling with is you guys have sort of taken opposite of what would be a normal position, right? I mean, typically I would foresee your client who's living in Oregon now demanding or arguing to me that Nevada is the inconvenient form, right? And that she wants to litigate the case up in Oregon. But you guys have kind of switched roles in this case, which is complicating the analysis a little bit. Does that make sense? Because it's not following the lines of what logically I would think the parties would be advocating for.
Right. And in terms of that, partially the reasoning for that is because of the long tortured history of the case, plus all of the criminal cases, the incarceration, in prison in Nevada. There's a lot of information in Nevada. There's a lot of witnesses in Nevada, especially in termination case when it relates to fault, plus the best interest. These children, I think it was pretty much agreed that they weren't going to really be part of the process in this. So wanting to know about their schooling and things like that really doesn't carry much weight at all in the analysis of the termination case. It's really about dad's fault and what he's done and what he continues to do in the state of Nevada. So our evidence regarding fault is all in the state of Nevada. There's nothing really going on in the state of
So I'm with you though. Sorry to interrupt, Mr. Fleeman. I apologize.
But it just seems like I understand that, but it seems like what is Nevada's connection to the case, though, right? I mean, what is Nevada's interest in deciding this dispute? That's where I'm kind of struggling as well, though. If both of these parties have essentially, to some extent, moved on, certainly if mom and the children have moved on, like, what is Nevada's interest in refereeing this, right? And expending resources to do so, right? I mean, that's
Right, and
a
that's
concern
little bit
for
of a separate
me.
issue because
It is,
I
maybe it
don't
is.
think that he legitimately should have free counsel in this case. He should have shown that he was indigent. The first case, he said he needed free counsel, and Judge Moss said, okay, he was making $85,000 a year at that point. So there's an issue. I agree, Nevada's expending, resources and things like that. He's getting free resources. In terms of the court's time, in termination, the children aren't residents of Nevada anymore. Mom's not a resident technically anymore either. But I think Dad is, and I don't know if that matters to the court since it's his parental rights or not.
If I'm,
you can, Miss Fuji.
thank you, just briefly, I'm with you, Judge. Don't think I didn't call Mr. Fleeman and go, he's gonna get a free lawyer specialized in 432 or 128, NRS 128. And, I'm going to, get an expert retained for reunification therapy. I said, you don't need, if you go forward, if you allow this case to proceed in Oregon, in custody, which it truly is, then he will have to hire his own counsel or not be able to afford his own counsel. He won't have a free attorney, and he can try and get back into his children's lives. The termination is just a yes or no question for this, but he's getting an overwhelming amount of defense at Nevada's expense. It is unnecessary. I can tell you, I deposed Ms. Ruiz, unrealistic expectations of a termination of parental rights case. So what ends up happening at the end is his rights are, my assumption would be his rights aren't terminated. That's it. Then he is going to be forced to refile a custody matter. And is Nevada equipped to hear that? No. So ultimately, it should be somewhere else. I agree with you wholeheartedly. I believe why they want to keep it here is because Ms. Ruiz was in the legal community, has ties to other legal professions here. I believe he ran for an elected position here in Nevada. There's a lot of unnecessary, just media and that's unnecessary to whether or not his rights should be terminated. So when you look at a termination case, I don't understand why they chose this route. I think their expectation was they would serve and it would go away and she'd win by default. But unfortunately, in Nevada, it's such a severe punishment to terminate someone's parental rights. So that was my 2 cents.
Here's where we're at. I'm gonna deny the motion for summary judgment. I agree that I'm not sure that it's relevant, but there is at least a disputed issue as to his residence. But the court acknowledges that there was no dispute at the time that the petition to terminate parental rights was filed, that the defendant acknowledged that he was a resident of Clark County, and so the court has jurisdiction to move forward with the petition. The issue on the inconvenient form, the court's not making any ruling today. That'll be we'll see how that issue develops as the time. I mean, it's not a requirement that there be an Oregon proceeding, but it may, if there is an Oregon proceeding and it does sort of gear up, then it may seem like it may factor into that analysis. But that issue, it seemed like the issue was a little more better briefed back in May, but then it never sort of got addressed by Judge Moss. The issue before me today really isn't the inconvenient form argument. To me, today was just the motion for summary judgment, and I think that there's an acknowledgement even today by plaintiff's counsel there is kind of a disputed issue as to residence to the extent that factors into it. But I'm certainly making a finding that we have jurisdiction and we're moving forward with the case. All right. Anything else that you think we need to address today?
Just if we do orders, Judge, I just want to make sure that I don't know if the court, if we can have the minutes suffice on the denial of the motion for summary judgment, because it'll most likely be utilized for the Oregon proceedings. So if we say Nevada has continuing jurisdiction, the motion for summary judgment was denied, but the court's not making any ruling on the form nonconvenience or on the simultaneous proceedings, that at least
it should be Nevada, because this is where the cameras are. The cameras are in Nevada, so they have to keep it in Nevada, guys.
Leaves the opportunity for the parties to brief further the need or necessity should arise for a UCC JEA conference.
That's fine. Mr. Fleeman, I'll let you prepare the order. If the two of you can agree on language, great. If not, submit orders and I'll take a look and make the decision. All right. Otherwise, I'll see you guys in January 9th.
Just for clarification, I believe there was a counter, well, it might not have been a counter motion, it was a reply. I think they requested fees. So I wanted to make sure that we addressed the issue at least today.
I'm sorry, I didn't hear that.
You had requested.
Did you request attorney's fees?
I did. I was irritated. I had to file. I am court appointed. I get paid either way. I'll withdraw that request at this time.
All right.
And just for the record, she didn't have to file. I said we could just bring it up at this hearing because it was already set.
That's all right.
I got a motion.
That's all right. The request for fees is withdrawn. All right. Thanks everyone for your appearances.
Thank you.
For a long time in this jurisdiction, going
Okay, I'm making a decision. I'm making a decision, guys. I really am. We're going to play these two videos. So, like 42 minutes more. And then we can just play this tomorrow and be okay. But that means, I think that means we're going to skip OJ today. I think that means we're just going to skip OJ today. We're just going to take one day off from OJ, which for 41 out of the 42 of you is fine. But one of you right now is sitting really pissed. Come on. Let's just skip one day. I'm going to play these two videos and then I have some real life stuff I have to do. So we're just going to skip one day of OJ. I know.
All right. This is D23-661332-R. Candace Ruiz versus Michael McDonald. Appearances, please. Mr. Fleeman.
Good morning, Your Honor. Jack Fleeman, bar number 10584 on behalf of Candace Ruiz, who's also present via Blue Jeans.
Good morning.
Val Fuji, bar number 5955 on behalf of Michael McDonald, the respondent in this case.
All right. Good morning. Do we have someone else online?
That would be probably Missy Garcia is my paralegal from my office.
Okay. All right. Gotcha. All right. All right. This is the time set for a status check. I think the parties had requested that the court move the trial date. We continued a bunch of the discovery and a bunch of the case deadlines, but you asked for this status check to remain on calendar.
That's correct, Your Honor. It was for a status of the expert. The parties have agreed to utilize Dr. Dana Anderson to perform the required psychological from the 2019-2018 custody matter. My office reached out to her via email. According to Dr. Anderson, she is aiming for February 9th, 2024 for the report. So with that, we can go ahead. And I think we have Mr. Fleeman, did we file that scheduling order?
Yeah, the order's filed, the trial's set, there's new deadlines. Dr. Anderson was appointed via that order that was entered in December. I was not aware of the report potentially being due in early February. That's fine. I don't know the status of the evaluation. I know that my client hasn't been contacted yet with regard to whatever part of the process she's going to play in that. But that's good to hear that it's moving forward.
Okay. All right. I'm just looking at that stip in order to continue all the deadlines, and you had Dr. Anderson's report due by April 1st. You had an expert deadline for experts other than Dr. Anderson at February 1st.
We may have to move that depending on what the report says.
Yeah, we may want to add a rebuttal expert deadline, I guess.
I have no opposition.
Especially since it's going to be ready so early.
Yeah, you have a close of discovery of May 3rd. So actually what you could probably do and you could do this by stipulation, is probably switch those dates, right? Because like I said, you have Dr. Anderson's report due by April 1st, and then you have the other expert deadline as February 1st. It's almost like just switch those around. Put your Anderson deadline at maybe like mid-February, right? Or maybe even the end of February, and then have April 1st as your rebuttal deadline, right? That might be the best thing to do.
I will stipulate that on the record, Judge, if we can, if that makes your minutes, that would be sufficient. Are you okay with that, Mr. Fleeman?
I am. The only concern that I would potentially have is if for some reason Dr. Anderson hits a snag and doesn't have it by mid-February, because I haven't talked to her. I'm getting the representation today that it will be done by February 9th or so, but I don't want her to say, hey, I need another week and a half and then miss that deadline and have it be a problem.
Well, and then also raises the question of, if let's even assume you get the report in the middle of February and you wanted to do some type of rebuttal expert. I'm not sure what that expert could accomplish in 30 days or 45 days even, right? I mean, it could be perhaps a report review and rebuttal based on the report. I don't know if they would have time to do any interviews or do any sort of further investigation, right? That could be a challenge, but maybe.
Yeah, I think with these types of evaluations, if there's going to be a rebuttal, it's probably just a review of the report and seeing if the proper testing was done and things of that nature. I don't know that there needs to be a secondary evaluation to rebut the primary one.
Well, if we're using the other report deadline as April 1st, right? So what and I think we could stipulate to that. I don't think we can go beyond that given our trial date. So if we use that as we've got April 1st as the rebuttal or the other report deadline, can we move Dr. Anderson's to the end of February, or do you want to do the middle of February just to give Dr. Anderson some latitude, right? That's the idea.
I think we could do it the end of February, and then we can work it out if it's not.
So the minutes will reflect that we're going to modify the scheduling order, that the deadline for Dr. Anderson's report will be the end of February 2024. What is that, the 28th or the 29th? It's a leap year. February 29th, 2024 will be the deadline for Dr. Anderson's report. And then the deadline for any other expert report, such as a rebuttal report to Dr. Anderson, will be April 1st, 2024. And then if for some reason...
And then the discovery cutoff remains the same, which should give time for a depot if we need it.
Yeah, and then I think what this does is it gives us some structure. It updates the structure so that if we run afoul of these deadlines, we can revisit this as when those dates approach. Does that make sense? So we have an understanding of what we're expecting. All right, perfect. All right, thank you both. Anything else?
No, Your Honor.
Nothing further, Your Honor.
All right, thank you.
Thank you.
For a long time in this.
Are you going to talk over me, sir? The jurisdiction. Sir, this is the judge. Sir, please stop talking. This is the judge.
Keep talking.
All right.
My counsel in Oregon is not present, so that's why I'm speaking now.
All right. Well,
I would just note for the record that Mr. McDonald is improperly in the chat making his arguments. I don't know if that's part of it.
I asked my office to text him not to do that.
But you're going to need more than your office. You're going to need the
I just want to
National
make
Guard.
sure that we had everybody before we proceed. And Judge Gordon, I believe you're on the line.
Yes. Good afternoon, Judge.
Okay. Good afternoon, and thank you for being available. I'm the one who asked for this hearing. So I'm going to go ahead and call the case, and we'll talk together about how to proceed. And I think just a moment. Do you have the name of that attorney that's on for? Okay. All right. Well, my name is Judge Easterday. We're here in the Yamhill County Circuit Court. That's in McMinnville, Oregon. The case. This is in the matter of Candace McDonald, now known as Candace Ruiz, and Michael McDonald. We had his attorney of record as a John Cochran, but I understand there's another attorney appearing on behalf of Mr. McDonald. Will you please give me your name?
Yes, Your Honor. This is Attorney Val Fuji, our number 5955. I'm court-appointed counsel in the Clark County matter.
Okay, very good. And on the video, we do have Ms. Ruiz, Mr. McDonald, the attorney. We have, and I was trying to get the official name, Mr. Gordon, Honorable Gordon, District Court Judge at 8th Judicial District Court Family Division. Did I get that right?
That is
Judge?
correct. That's correct.
Okay. And here in Oregon, we did have that Clark County, Nevada case D-15-518-905-D judgment entered as a foreign judgment just recently. Mr. McDonald has also filed in Oregon a motion to modify that Nevada parenting plan. And given that, it seemed the next step would be for me to have a UCCJEA, which of course stands for the Uniform Child Custody Jurisdiction Enforcement Act. The statute allows a court may communicate with a court in another state concerning a proceeding arising under this act. The court may allow the parties to participate in the communication. A record must be made of the communication, and so parties were informed, and that's what we're doing today. Judge, is there anything that I missed before we continue?
No, let me just call my case over here. It's D23661-332-R in the matter of the parental rights of. And then I just want to note Mr. Fleeman's appearance. Mr. Fleeman, will you make your appearance, please?
Yes, Your Honor. Jack Fleeman, Barner 10584 on behalf of my client who's also present.
Guys, we got a sub. We got a sub on Twitch. Fozzie gifted 1-tier sub to Nan, which is crazy because I haven't set up tiers yet or anything. I don't even know what he paid for that because I didn't put any prices in. But the reason why this is really good is because if you watch my live streams and you get ads, if you have an Amazon Prime account, you're able to subscribe to one Twitch channel for free every month. You got to do it every month, okay? So if you use that subscription to subscribe to Court Vibes on Twitch, you can watch all of this with no ads every day. Every day. I don't know if it's fully set up yet, but we're working on it. We're working on it. So you guys can watch this with no ads. It's cool. It's cool. You guys get to see this with no ads. I see that. I don't know where the sub button is because you know what, Tina? I haven't set it up yet. Working on it.
That's noted.
All right.
And who's your client?
It's Ruiz in Nevada.
Ms. Ruiz, thank you. Okay. Okay, well, thank you. So, and I always feel a little clunky on these hearings. I do them so infrequently, but I was looking at our statute. I was looking at the jurisdiction to modify and the procedure for that. But I guess more importantly, I thought that because my understanding, judges, is there's simultaneous proceeding. There's actually an active proceeding regarding the custody of the children in Nevada at this time that may kind of stall things. The statute says a court of this state, which is Oregon, may not exercise its jurisdiction if at the time of the commencement of the proceeding concerning the custody of the child has been commenced in a court of another jurisdiction.
Well, the proceeding. The proceeding that's pending in Nevada is not a proceeding for custody. The custody action, the D15 case that you referenced, that you have registered the foreign judgment, that case is currently inactive and closed in Nevada. The case that is active in Nevada is a petition to terminate Mr. McDonald's parental rights. That's the D236613332 case, and that is pending. So we essentially have two separate proceedings that are pending at the same time and potentially in conflict. One is the motion to modify custody that's pending there in Oregon, and then the termination proceeding that's pending here in Nevada. I think there are a couple of issues that the courts need to discuss and agree upon or address, and that is, one is the residence of the parties could be an important consideration. There's no dispute that mom and the minor children are residing in Oregon and have been residing in Oregon for I believe at least 3 years, the last 3 years. There potentially is a dispute as to where Mr. McDonald is residing. He contends that he's now residing in Arizona. That's the representations he's made to the court, the position he's taken in Nevada. I'm not sure what he's alleging there in Oregon. I'm assuming he's alleging in Oregon that he's a resident of Arizona. Mom may dispute that point. That may be a fact question. It may have some bearing in the sense that if in fact dad has left the state of Nevada and is residing in Arizona, then in fact at the time that the judgment was registered in Oregon and the motion was filed there, all parties had left the state of Nevada when that petition was commenced. And if dad is in fact residing in Arizona, then Nevada would not have jurisdiction over that custody proceeding, the one that's pending in front of you. And then what the court would grapple with, or what the court is grappling with here in Nevada, is whether it wants to proceed with the petition on the termination of parental rights, or whether it feels it's in inconvenient form, given that there's an action pending for custody there in Oregon. The parties have all left the state of Nevada and
steal one of their Oreos. It's called a delivery tax fee.
the custody action here is inactive and closed.
Free Oreo.
So I think the first issue we need to address is the issue of dad's residence, and then we can discuss the issue of inconvenient form.
Okay. All right. I'll turn to, I'm not sure if the parties are prepared to put on evidence. I'll turn to Ms. Fuji.
Thank you, Your Honor. I may be able to add some clarity, and I know Mr. Fleeman can do this as well. The issue, just procedurally, my client successfully completed his parole and was honorably discharged on or about February 3rd of 2023. After that, he did a brief focus psychological assessment, April 3rd, 2023. He filed an affidavit in support of a registration of an out-of-state child custody determination in Yamhill County on March 31st, 2023 in 23 DR 05784. He also attempted to file a motion to modify custody in the same case, but procedurally it was ineffective. Ms. Ruiz moved to terminate his parental rights in Nevada and filed that on April 4th. The parties first met with Judge Easterday at a UCC JEA conference. The court minutes from that were done on May 5th, 2023. Both Mr. Fleeman and I were there. We were instructed by Judge Moss in anticipation to file briefs on the UCC JEA issue. Both counsel filed briefs that will address a lot of these issues, I think, before this court. So if that would be relevant, I'd be more than willing to share that and provide that to Judge Easterday. The court at that time, Judge Moss said discovery was open on the issue of my client's residency. He had filed proof of a change of address in White Hills, Arizona on April 24, 2023, and through the commencement of discovery provided proof of a utility bill, driver's license showing residency in Arizona. Then counsel for Ms. Ruiz did a motion for summary judgment on this UCC JEA issue, which came before the court, and that was denied without prejudice. And that was just procedurally the background I wanted to offer.
And this is Attorney Jack Fleeman in Nevada. If I may, I just want to correct part of the record that was made there, in that while her client did file to register the custody action in Oregon sometime around, mid-year, spring of last year, our motion, or our petition to terminate, was actually filed last January, more than a year ago. It was not filed in April. It was several months later that Mr. McDonald filed the first attempt to register in Oregon. It's now over a year later. We have a trial set in the petition to terminate for June. My preference is to be able to file maybe simultaneous briefs on the issue of residency and inconvenient form.
I would not be opposed to that, counsel. I think if everybody, the more information, the better. Our request, of course, is that Nevada stay to proceeding under NRS 125A 3653 and allow, and you know, I know we both have different positions. We would like, my client would like, as it is a non-convenient form in Nevada, and that there's a simultaneous proceeding to argue those facts. We can brief and then argue those later.
My preference would be a simultaneous brief and then maybe a short evidentiary so the courts can actually take some testimony from the parties, if possible.
I would not oppose.
Mr. Fleeman, the standard for
the
standard for residence is presence. What's the offer of proof as far as what your client can show to dispute Mr. McDonald's assertion that he's not physically present in the state of Nevada, that he resides in Arizona?
The offer of proof is that he is physically present in the state of Nevada. We believe every single day, but definitely the majority of time. And he does spend overnights in the state of Nevada as well. We do believe he's also working in the state of Nevada now, as in addition to that.
And so the evidence that would be proffered at the evidentiary hearing would consist of what?
It would consist of an investigation that's been done that shows where he has been located, where his car has been located, where he has gone during the days. We also have his social media previous to this, or previous to the last hearing, where he was posting where he was in Las Vegas pretty much every day, although he seems to have shut down the social media side.
And then even regardless of his residence, either court is in a position to be able to decline jurisdiction, correct?
I believe that Nevada's in the position to relinquish or decline to exercise in favor of Oregon. I don't think it could be the other way around, based on the statute that the Oregon judge quoted, which is the same in Nevada, that states that once there's a proceeding that's commenced, it can't go forward until the other state, I believe, recognizes itself as an inconvenient.
You would agree with me, though, that the proceeding that's been commenced in Nevada is a petition to terminate parental rights. It's not the custody proceeding. The custody proceeding in Nevada has been closed for quite some time. And so if, in fact, Mr. McDonald left the state of Nevada, correct, then Nevada lost jurisdiction over any potential new filing, such as his newly filed motion to modify custody.
I don't necessarily agree with that. I agree in part that the termination of parental rights isn't a custody proceeding under the custody statutes. However, under the UCCJEA, it is defined as a custody proceeding.
Correct. It's a proceeding in and of itself, but it's not a proceeding to modify custody. It's a proceeding to either terminate parental rights or don't terminate parental rights. So if there's
substantively,
right, if your client, if the court finds that he left the state of Nevada, right, then it lost jurisdiction. And if your client now wanted to file a motion to modify custody or to somehow modify the controlling custody order, the court wouldn't have jurisdiction in Nevada to hear that.
Potentially. I don't know. I need to brief it because the issue is a party could just leave the state and divest the state of jurisdiction if we're talking about the termination case, which, and again, under the UCCJEA, The termination is a custody proceeding by definition under the
I understand. You're
UCCJA. I
telling me
understand
you're
it's not
going back
to
over
modify.
information. You're going back over information I already know. You're not answering my question. My question is, I'm clarifying that the custody case, if he's left the state of Nevada, custody rests in Oregon. To the jurisdiction to decide custody rests in Oregon. I would lose all jurisdiction if he's left the state of Nevada. And so essentially, the petition to terminate parental rights is kind of a dead end. It either gets granted or it doesn't, and then it ends Nevada's contact with this case, right?
Yeah, I'm not quite sure of your view on the termination. That's why I keep going to the same thing, because it's a dead end, but if you terminate his rights, it severs the ability. Okay, he's holding up an ID to the camera.
So, but why are we going through this whole proceeding to terminate his parental rights when he's actively trying to establish a relationship with his children in Oregon? Doesn't that seem sort of pointless?
No, absolutely not.
Okay.
He's only trying to establish his custody because we filed the petition. He could have done many things prior to filing in the state of Oregon. He waited several months until the petition was on file in Nevada before he did anything in Oregon. And now it's been over a year.
There could be 1,000 other reasons why he waited. It happened to be that it was after your client filed a petition to terminate parental rights. That doesn't necessarily mean that was the reason why he did it. There could be other reasons. But that's
a factual issue, an evidentiary issue.
It is a factual issue, but the challenge that the court's having is that you're asking, potentially these parties are living in other states, and you're asking a Nevada court to expend resources to decide a controversy that potentially it has no interest in or stake in. If in fact he's left the state of Nevada and the children have been living in Oregon for the last 3 years, and there's a case pending in Oregon. It just seems okay. Well, let's do this. If you think that there is a dispute about,
well, Judge, can I? Yeah.
Sure.
Judge Gordon, I guess when I'm looking at the statute, yeah, and help me, walk me through, because I'm interested in your point of view. I don't know what the statute is in Nevada. Ours is ORS 109.757, simultaneous proceeding. It says, a court of state, Oregon, may not exercise its jurisdiction if at the time of the commencement of the proceeding, a proceeding concerning the custody of the child has been commenced in the court of another state. So a proceeding concerning the custody, and you're saying that a termination of parental rights does not concern the custody of a child. I mean, to me, it seems like the ultimate decision of losing custody, but you're saying that you have a different point of view on that?
Yeah, I mean, I don't have the ability to modify custody as part of this petition.
Well, I'm just saying that it says, because you're saying that the termination of parental rights has no bearing on the motion to modify. But when I read the simultaneous, it says, if Oregon can't exercise its jurisdiction, if at the time of the commencement of the proceeding, which is, I'm assuming it's the motion to modify in Oregon, a proceeding concerning the custody of the child has been commenced in the court of another jurisdiction having jurisdiction, unless the proceeding has been terminated or stayed by the court of the other state. I mean, when I read that, it sounds like unless, the termination of parental rights, it's not a custody proceeding per se, but it does concern the custody of the child. But it sounds like you have a completely different point of view. But then if I go down to the jurisdiction to modify, if you didn't have that termination of parental rights, then we would just automatically go to jurisdiction to modify, which, and that's the step-by-step, could Oregon make an initial determination? Yes, it would be the children's home state. And the court of the other state determines that it no longer has exclusive continuing jurisdiction. I mean, help me understand how you
well, that second question, did you just
how you think the termination of parental rights action doesn't it sounds like it's not relevant or something to this conversation.
Well, so maybe I could clarify. I know that our statute is NRS 125A.305, says custody proceedings include termination, parental rights, and that dependency court also falls under that. But in Nevada, when parties file to terminate parental rights, they file a different case number. They file it. So they are like separate yes or no answers. So maybe that will clarify. The simultaneous proceeding is NRS 125A.355. I was asking this court to stay the proceeding under forum nonconvenience, that Nevada should decline. Because normally, since Nevada made the initial decree.
I don't understand YouTube. Why do they do this? Nicole has her @ sign. Is she the only one that we saw with their @ sign? I think so. It looks like it, maybe. Why are they doing this to us? Why don't they stop doing this?
A divorce and custody order, Nevada would have exclusive continuing jurisdiction until it doesn't. And I believe it didn't when Candace moved. And now, especially if they're going forward with custody, anything and everything involving the children, meaning reunification therapy, say this court says we don't terminate, Nevada says we will not terminate, then where do you go from there? The case should proceed in Oregon, because that's where all the state CPS, Oregon, law enforcement, Oregon, everything that mom's concerned about, and reunification therapy would be around the kids and where they reside, and nobody lives in Nevada. So Nevada, I agree with the court on that issue, that they would decline to exercise jurisdiction, and it should be Oregon.
Judge, can I also clarify as well? There was temporary orders from
No,
the Nevada court that said that
I don't know who's Mr. McDonald.
matters and to
Mr.
get
McDonald.
an evaluation. Both of those requirements have been fulfilled.
Are you going to talk
she's
over me,
moved out
sir?
of the jurisdiction
Sir, this
of
is the
Nevada. I
judge.
don't know.
Sir, please stop talking. This is the judge. You're represented by counsel. All right?
My counsel in Oregon is not present, so that's why I'm speaking.
All right. Well,
we're just talking about procedural issues right now, Mr. McDonald. So please hold your thoughts. Judge Gordon.
Well, I mean, listen, you raise an interesting question, Judge. As Ms. Fuji pointed out, in Nevada, it's two separate cases, right? I mean, I have a custody action on one hand, and I've got a petition to terminate parental rights action. There's two separate cases. So in Nevada, they're certainly perceived as distinct, right?
Now in Oregon, we would consolidate those cases. Is that not how you do it in Nevada, since it's the same children, the same family, the same parents?
Yeah, they're not consolidated. I mean, they're two separate cases. And different relief would be different relief.
They're separate. We file separately. So in a normal custody case, they'd have to retain counsel. In a termination case, they get court appointed if they qualify as indigent. The standard's higher, it's clear and convincing instead of preponderance by the evidence. It's just a heightened standard. So routinely they file separate. We file separate actions.
Well, yeah, they're filed. Yeah, we have separate case numbers, of course. I just meant they're consolidated, and typically the court would then decide which case proceeds first. But
yes,
I don't know. I just think it's interesting the fact that it's two different case numbers. But the bottom line is the mother and the children have been living in Oregon. So I think it ultimately a motion to modify. We haven't had the hearing, but I think a lot of these factors will be met. It's just that termination case that, to me, seems like that should be resolved, and that any motion to modify should be stayed. But there again, I'm happy to continue this, read the briefs, kind of understand a little bit deeper as to the arguments. What are your thoughts, Judge Gordon?
Well, I think we perhaps need to resolve the issue of residency one way or the other. I mean, I have previous briefs there from earlier this year regarding
can you hear me?
The parties' respective positions.
I can't hear the Nevada judge. I can't hear Judge Gordon.
Oh, okay.
Can you hear me?
Judge Gordon, are you Can you hear us?
Yeah, I can hear you. Can you hear me?
Let's see. Okay, how are we going to do this?
Are we muted?
Do you have his clerk or anything?
Can you hear me? Why don't we log? You want to log out?
Okay, Judge Gordon, I think I can hear you now.
Oh, okay.
Okay, now I can hear you.
I mean, I already have the benefit of the parties' briefs regarding the form, the inconvenient form arguments.
Oh, you're, I can't hear you anymore. Okay.
Can you hear me now?
Yes.
Okay. So well, let me ask you this. You have a motion pending there in Oregon to modify custody. Is that what it is?
He filed a motion to modify, but it's just at ground zero because we're gonna have in this UCC JEA. So it's in the file. It hasn't gone anywhere because I didn't know if we were gonna proceed in Oregon on a motion to modify. And so it's, I thought we would have to have this conference. And when I just read the statute jurisdiction to modify, it says, you know, let's see, a court of the state may not modify a child custody determination made by a court of another state unless a court of this state, Oregon, has jurisdiction to make an initial determination, which it would seem like it would since they've been living here 3 years. And then it's, there's the court of the other state determines that it no longer has exclusive continuing jurisdiction, or that a court of this state, Oregon, would be a more convenient forum, or a court of this state determines that the child, the child's parents, and any person acting as a parent do not presently reside in the other state.
And tell me again, that's the...
So I thought I needed to have that hearing before we moved forward on the motion to modify.
And give me again the statute there in Oregon that you're reading.
But then I thought we were at a standstill when I read that simultaneous proceeding, given the TPR in Nevada, where it said I cannot exercise jurisdiction unless Nevada stays its case or something. You know, anyway.
Yeah.
I would just note for the record that Mr. McDonald is improperly in the chat making his arguments. I don't know if that's part of
I asked my office to text him not to do that. Please, Michael, don't do that. Please.
Yeah, and I don't have access to chat, so I can't see it. Just to let you know.
Thank you. Please don't, Michael. It's inappropriate.
Yeah, neither do I. Well, I think that I'm happy to look at additional briefing. I think that the residency issue probably needs to be addressed. We may need to do just a short evidentiary hearing on that. I'm not sure if we do that, you need to do that jointly, or if either jurisdiction can make that determination. I think under the statute, either jurisdiction can make that finding, but and potentially, I guess we could conduct it jointly. That's why I was trying to understand what.
And Judge, if you feel like
would be put on to address that.
I was just going to say, if you feel like we can proceed today at this time with a brief evidentiary hearing, we can certainly do that as well at that time.
I think I'll probably get objection from the parties. Mr. Fleeman probably wants time to prepare.
That's correct, Your Honor. I need to provide the exhibits that would be introduced at the evidentiary hearing, and probably have a third-party witness regarding the investigation that's occurred.
And you know, I have what I produced in our 16.2 that's not a part to, that hasn't been provided to the court yet, is I have a copy of a lease and his driver's license. And then he responded to written discovery, 2 sets of written discovery. And I think he was deposed as well. So I have that I would offer in advance in evidence in support of his residency out of Nevada.
Can I propose something? I mean, I'm willing to offer any questions, and let's just proceed. It's been way too long. It's been over 2 years since I've been able to see the children, and the more the time that passes.
Okay, we understand.
So please, anything.
We understand, Mr. McDonald. We understand.
Procedural stuff. There's no jurisdiction in Nevada. There should be allowance.
Okay,
to proceed in Oregon. Thank you.
Please mute Mr. McDonald. So Judge,
well, this is
my understanding is that I can't.
This is my concern that if that.
Oh,
I'm sorry, Judge. Go ahead.
Go ahead, Judge.
No, I interrupted.
Oh, do you agree that I can't proceed until Nevada? Is anybody on speaker? Because if you are, it usually echoes. How I read the statute is that I can't proceed until Nevada relinquishes jurisdiction. Go ahead, Judge.
Well, see that's where we kind of differed, and I didn't look at your statute, but I didn't read my statute that way because I viewed what was pending here was just this termination of parental rights and not a custody proceeding per se. And if in fact the father had left the state of Nevada, then there would be no jurisdiction here in Nevada to commence a new custody proceeding. In other words, and a proceeding would be like a motion to modify. So if he has in fact left the state of Nevada, then the only thing that would sit in Nevada and remain potentially would be this petition to terminate parental rights, which isn't everything. That's why I'm not understanding why jurisdiction would stay in Nevada. I think that's why, it would make more sense to be there in Oregon. But I recognize that, yes, the petition to terminate parental rights is pending here in Nevada, and whether he's a resident of Nevada or Arizona, the court has that jurisdiction. But it just, I don't know why that's going to go forward when there's a motion to modify custody pending there in your jurisdiction. And he's trying to reestablish contact with his kids.
All right. It's my understanding that Mr. Fleeman, you'd like some time to brief. Are we going to look at another date to come back? Is that, I believe, where we are?
That's what I would request, Your Honor, yes.
Are the parties ready to proceed with the evidentiary? I mean, not today, but are you ready like in 2 weeks? I mean, we're supposed to expedite a resolution of this, correct?
Well, we are. It's supposed to be 6 months, I think, under SCR 251, if this is a custody proceeding. But in terms of an evidentiary...
I'm talking in terms of the UCCJEA has language that says that these matters are to be expedited and handled in, expeditiously. That's in the UCCJA.
Well, I'm assuming my client would need to be present, and because it's an evidentiary hearing, which she would just need to make arrangements. So I think that would be the only issue about when the evidentiary hearing would be. She would need to just make arrangements to come here.
Do parties have a sense of how long the hearing would take?
For me, not long, I don't think. I would front load the exhibits I have in support and then make him available for questioning.
Yeah, I think a couple hours at the most. I don't see it being more than that.
So an afternoon?
Okay.
Yes, sure.
Okay.
I was hoping much shorter, like a half hour or hour.
We know it's 2 hours.
The reason why we shouldn't do it via video conference?
I don't have any objection to it. I just didn't know if the court was okay with that.
I have no objection.
No, if you do a video conference, no one can tase him. Come on, Judge. Come on, that's so mean.
Judge Easterly, how do you feel about that?
Oh, that's fine.
What about,
There's no way to proceed
I was
today.
looking-
what about either February 13th or February 14th in the afternoon? I have both of those afternoons available.
Are we on the same time zone?
We are Pacific time. I'm available on the 13th, but on the 14th, I am on a abuse neglect track, and that's every Wednesday. So I'm not available on the 14th, but I'm available on the 13th.
I'm available on the 13th as well.
Judge Easterly, does that work for your calendar?
Yes, and just for the record, Easter Day, just like the holiday.
I'm sorry.
So on the 13th, that's okay. What time are we thinking? I would be able to do it like starting like 2:30 would be the best. I could probably start at 2 o'clock and have the rest of the afternoon.
I think 2 o'clock works. Let's do 2 o'clock.
Okay. Okay. So we'll do WebEx just like we're doing now.
We'll do WebEx. The primary issue will be Mr. McDonald's residence, correct? So.
Can I just answer the residential thing right now?
No,
I have
no.
all the evidence.
No.
It's ridiculous.
So I'm assuming the order of proof would be Ms. Fuji would begin, right? And then Mr. Fleeman would have a chance to respond. And then obviously you can present briefing as far as the issue of residency as well as the issue of form non-convenient. We'll address that at that time as well. I don't know what kind of evidence would need to be put on or if that would just be the argument you could make at the conclusion of the presentation of evidence.
That's fine, Your Honor.
Yeah, we would stipulate to argue on that issue.
I'm sorry, Mr. Fleeman, you'll just stipulate to just argument on that? Is that what you said?
On the form non-convenience, if we can brief it at the time, then yeah, just the argument.
Okay. All right. All right. I think that resolves it today. So we'll continue this to February 13th at 2 o'clock.
We have a deadline for the briefing, Your Honor.
Yeah. I was looking at maybe the 8th, February 8th. Judge Easterday, is that okay for you?
That sounds good.
And
unless there's any other issues, we can sign off and we'll continue this to Tuesday, February 13th at 2 o'clock. And I'll reserve the rest of the afternoon for that.
Your Honor, do we want to get into the Oregon court as well? Just a copy of what we file in Nevada in some way so that Judge Easterday has it?
Yeah, I don't know how to.
Yeah, you can file it in the Oregon, let's see what case, I'm trying to find the case number, the Oregon horse number. You can also give me a courtesy copy. You can find my email address in the Oregon State Bar directory.
Thank you, Your Honor.
All right, thank you all.
Okay, all right. Well, we're going to hang up now unless there's anything further.
That concludes it. Thank you, Judge.
Okay, let's just find out really quick if it actually did happen on February 13th.
For a long time in this,
Just looking, or if it was continued, because we know it. Yep, it did happen. It happened on February 13th, and it was 2 hours long, and we're going to see those 2 hours tomorrow. And I'm going to try not to be so distracted tomorrow. I know today I was pretty distracted, but I before you leave, wait, don't leave yet. Wait. Sunday, we're having a special live stream because Linus and Nan asked for it. This Sunday, I'm going to do a live stream. I'm going to do my normal one in the morning. Don't worry. I can't break that. But 1 o'clock Eastern Standard Time. We're going to do a live stream on Sunday because no one else really streams on Sunday, so everybody gets really bored. But this one's going to be special. I am going to gift 60 memberships during this Sunday live stream. So if you're not a member, make sure you come and chat a little bit. I think it raises your chances. I don't freaking know how YouTube works, but try to chat a little bit and you might get a membership to this channel for free on Sunday. Okay? So come on Sunday, 1 o'clock Eastern Standard Time. I'm going to set it up soon. That way you all have it, upcoming and you can see when it is your time, no matter where you live. Don't ask me again what time it is, because I'm just going to tell you to check the link, because you all live in different parts of the world and you all have different time zones, and I'm not converting nothing. I'm going to put it up as a live stream, and then I'm going to tell you to just go check it yourself, because I don't know your time. I'm going to tell you 1 o'clock Eastern Standard Time. And you can either do mental math or you can just click the link and go and look. But yeah, free memberships, Sunday. All right, guys. Thank you for coming out. I really, really appreciate it. I will see you all again really soon, okay? Bye, guys. No OJ today.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no